Please call the list.
Item number 1.
Item number 1, I'm the petitioner.
My lord, in this matter, Mr. Arnam Chakravarty is appearing for the state.
This is for withdrawal, my lord. My lord, I'm carrying the instruction. Only one indulgence, my lord, if it pleases to your lordship. My lord, kindly come to page number 45. The issue is, my lord, the petitioner wanted to nominate his children instead of his wife. Now, my lord, the DI said, no, you have to nominate your wife. Now, he is, my lord, a cancer patient. He is agreeable to this, my lord. Only if that direction can be passed that he will nominate his wife.
No.
And he
Then
will
it
go-
will go back to its own position.
Yes,
Sorry.
my lord. No, my
It
lord.
was
It is for withdrawal.
mentioned for withdrawn.
Yes, my lord,
Sorry.
it is withdrawal. I'm not pressing for
What is
anything
this?
else. Only that if the petitioner go comply
Yes, sir.
with the, my lord, formalities, if the authority can cooperate, my lord, that is all. Right.
You cannot take dubious stand.
I'm not taking, my lord,
Mentioning the matter that you want to withdraw and now you are praying for a direction.
my lord, I'm withdrawing, my lord. I'm not saying anything.
I am not insisting upon you to withdraw the writ petition. It's your own volition. You take a decision. But it does not mean that at the time of withdrawal, you will pray for a direction.
I'm not praying for a direction. If any observation can be made.
Sorry, that is not permissible. Then matter is to be heard on merit.
Grateful, my lord.
Matter has come up in the list under the heading to be mentioned, quote unquote, on being mentioned by the learned advocate representing the petition. Stop. Next paragraph. Learned advocate representing the petitioner submits on instruction that petitioner does not want to proceed with the matter. And in support of same, a letter dated 23rd July 2025, which the learned advocate has received from the petitioner is placed before this court and same is taken on.
Can I have the flag?
Next paragraph. State respondents are represented by learned advocates.
I'm for the private respondent.
Which respondent?
7.
Wife,
7. Respondent number 7.
State respondents and respondent number 6, 7. Respondent number 7 are represented by learned advocates. Next paragraph. In view of aforesaid submission made on behalf of the petitioner, writ petition stands dismissed on the ground of non-prosecution. Parties to act on the server copy. Next matter.
Item number 2.
What is different? Different.
যে পরীক্ষা এটা টেন্টেড আমি যদি কোনো অর্ডার পাই তাই আমি
एक कौन लिस्ट है नाम से टेंटेड नाम क्या
পুরো একটা সুযোগ চাইছে পরীক্ষা সরকারি এরা টেন্টেড এরা করেছে খুব যেমন বসার সুযোগ তো ওরাই আছে, ওই তো আছে। Tented কথা। এখানে তো পেয়ার ম্যাচ করছে না। কম্পিউটার করে তো টেন্টেড গুলো বড় সুযোগ দিচ্ছে তোমরা।
না,
হ্যাঁ, সুপ্রিম কোর্টকে সুযোগ দেয়।
You prayed for time twice before the coordinate bench. Now you are praying that matter is urgent. This matter was first heard by the coordinate bench on 23rd of March.
Yes, ma'am.
Then the commission was directed to obtain instruction. It's a writ petition of 2023.
Yes, ma'am.
Then 19th February 2025, after 2 years,
Yes, ma'am.
when matter was taken up, then you on an accommodation is prayed for on behalf of the learned advocate for the petitioner.
No, my lord, at that point of.
No, at that point of time, it was not that was subsequent development. An accommodation is prayed for on behalf of the learned advocate for the petitioner. Prayer is allowed, matter be included in the combined month list of March 2025. That is the order dated 19th February 2025. Subsequently, on 6th March 2025, learned advocate for the petitioner submits the issue involved in this present writ petition is under consideration. 19th February 2025. You prayed for time. Subsequently, matter was taken up on 6th March 2025. Learned advocate for the petitioner submits that the issue involved in the writ petition is under consideration before the Honorable Supreme Court in a pending special leave petition. She prays for that the matter may go out of list for the time being. It was the prayer on behalf of the petitioner since the matter was pending before the Honorable Supreme Court. That is Boisakhi Bhattacharya Chatterjee matter. Then subsequently, in view of the judgment of the Supreme Court, coordinate bench observed prima facie there is no scope for consideration the prayer of the petitioner in the present writ petition. Then there was a prayer made on behalf of the petitioner to matter be kept pending, matter was released. And today matter has become urgent. And you are praying for release of the matter. See the order. If you have any doubt, 9th February 2025. দেখাও তোকে অর্ডারটা। No, let him see. Matter has been mentioned, Mr. Boisho, at least thrice. 2023 writ petition. It was part heard before a coordinate bench. Twice accommodation was prayed for on behalf of the petitioner. Today, jumping queue, I have to take up this matter. I fail to understand. Well, since you are praying for release, let me release the matter. Matter has come up in the no, it was prayed for. That's why Mr. Monjum, the matter has come up under the heading to be mentioned. But I cannot give any preference to this matter. I have made myself clear to your junior. Matter was mentioned thrice.
I am sure not that adjournment was prayed for because of the.
Twice. No, first adjournment, that was not the case. In the second adjournment, it was the issue that the matter was pending. Matter has come up in the list under the heading to be mentioned, on being mentioned by the learned advocate representing the petitioner. Stop. Next paragraph. Learned advocate representing the petitioner prays for giving precedence to this matter and matter needs hearing and matter needs immediate hearing. Stop. Next paragraph. On perusal of record, it appears that the writ petition, it appears that the writ petition was heard in part before a coordinate bench, video order dated 23rd March 2023. Stop. Subsequently, matter was taken up twice, on 19th February 2025 and subsequently on 6th March 2025, when on behalf of the petitioner accommodation was prayed for. So, ultimately, matter was released by the coordinate bench on 24th April 2025. Now, released by the coordinate bench on 7th August 2025. Next paragraph. When matter was mentioned before this court, I was of the when matter was mentioned before this court, this court was of the view that matter needs to be heard on being included in the monthly combined list of September 2025. But the learned advocate representing the petitioner prayed for hearing out of turn. Stop. Having considered the issue involved in this matter and the order passed by the coordinate bench on earlier occasions, considering the submission made on behalf of the petitioner, this court is not inclined to hear the matter by jumping the queue. Stop. Next paragraph. Writ petition stands released and be placed before the Honorable Chief Justice for assignment. Next.
Item number 3.
Nothing is there. Nothing.
Yes, what you are praying for?
I challengingly did, sir, my lord.
So today, what is your stand?
Lord, my only.
Yes.
My representation, my lord, 23.
What is the matter about?
My lord, there is a representative election, and I am one of the candidates of the said election.
my lord, the headmaster of the school, uh, of the school, conduct the election, my lord, violating the all guidelines. That is my grievances, my lord. The election sheet, result sheet, my lord.
Who are you?
I am one of the candidates. Teacher.
Under which category? Teachers category.
Teacher representative.
Yes.
Yes.
And my lord,
So did you lost the election?
yes.
When the election was held?
28 April 2020.
Now you contested under the teachers representative category and you lost. Then you lodged a complaint before whom?
Before the, my lord, president and my lord, the president of the school, my lord.
President of the school.
Managing-
What jurisdiction he has got to decide the election based on which he was elected?
That is why, my lord, your lordship direct me to serve upon the copy to the board, my lord.
What is the illegality?
My lord, kindly see the result sheet, result, my lord, vote counting sheet to
Where demonstrate that where is the illegality? Where is your result sheet?
page 18, my lord.
Place the matter properly. You know the facts. I do not know the facts. So you have to demonstrate that this is the illegality. You are practicing in High Court. Yes.
Yes, my lord. My lord, will kindly see serial number 4 and serial number 6.
What is the serial number of petitioner?
1, my lord.
Yes. Then where is the illegality? Serial number 4 and
4 and 6, my lord.
yes.
Both of them are got 11 and 11 vote, my lord.
12 and 11. 11 and 11. Yes.
11 and 11.
Yes.
But without any toss, without any, my lord.
But you are not. You didn't receive 11 votes. So how you are affected? I could understand that you obtained 11 votes. That is the consideration so far. Serial number 4 and serial number 6 are concerned, but that cannot be your grievance. Why you have filed the writ petition?
And my lord,
You didn't obtain 11 votes. You obtained 6 votes. Last but one candidate in terms of election result. So how you are affected?
and my lord, one thing, my lord.
Answer the query of the court. Don't go to other point. First answer the query. No other thing. First clarify this. Sure. Petitioner is one of the teachers of Bilshara Robindranath High School within bracket HS, Hubli, who has come up with the writ petition questioning election procedure resorted to by the school authority, by the said school authority, by the said school authority for reconstituting the managing committee, Stop. Election under teachers representative category was held on 28 April 2025, where petitioner contested along with 6 other candidates. Stop. From election result, which is at page 18 of the writ petition, it transpires that petitioner received 6 votes. Only 2 are to be nominated on the managing committee based on election. 3. Petitioner received 6 votes, whereas 5 other candidates obtained more votes than the petitioner. As a result whereof, একই সঙ্গে, as a result whereof, petitioner was not elected. So as per norms, there shall be 3 teachers representatives on the managing committee of a government sponsored institution. Stop. In terms of votes received by the respective candidates, petitioner ranked fifth.
Yes.
No. Petitioner ranked fourth.
Fourth.
Stop. Next paragraph. A case is attempted to be made. A case is attempted to be made out in this writ petition that while permitting Prashanta Kumar and Sudarshan Mondal, who received same number of votes, that is 11, to be members, to be teachers representatives on the managing committee, appropriate procedure was not followed. Stop. But fact, stop. Fact, the fact remains, both Prashanta Kumar and Sudarshan Mondal received 11 votes each, and petitioner received 6 votes. Therefore, there is no possibility, so far petitioner is concerned, to get chance to be elected as teachers representative and to function as one of the members of the managing committee. Stop. Hence, no relief can be granted to the petitioner. Stop. Writ petition stands dismissed. Urgent injunction. Okay, next.
Good.
Affidavit of service.
File it. Affidavit of service filed on behalf of the petitioner is taken on record.
In item number 4, I am appealing for state, my lord.
That is job user.
Now, দেখো।
Whether the post is lying vacant.
My lord, the post is vacant, but this is not the case of a job loser. He is plain simple absentee candidate. Now, if this is allowed, then a new avenue will be opened.
It will be a matter of course.
Yes. And we have a huge number of absentee candidates in upper primary.
So you take decision. And I also find that this recommendation was made on 6th March 2025. 6th March 2025.
Yeah.
And this application was made
On 30th June.
30th June. That is beyond 90 days.
Yes. So that is for the purpose of joining. That will not be for held to be for the purpose of extension of
Extension.
this application has to come to us within 90.
Here you take decision.
Very well. My lord will kindly excuse me.
Issue. Learned advocate representing West Bengal Central School Service Commission, hereinafter referred to as Commission, quote unquote, on instruction submits that the vacancy where petitioner was recommended, VDA memo dated 6th March 2025 is still lying vacant. Stop. But it is also submitted on behalf of the Commission that it is not a case where petitioner has lost job in terms of the judgment of the Honorable Supreme Court dated 3rd April 2025, passed in civil appeal arising out of special leave petition number 9586, na? Special leave petition number 9586 of 2025 within bracket State of West Bengal versus Boishaki Bhattacharya Chatterjee and others. Stop. Petitioner could have joined the post in terms of recommendation dated 6th March 2025, but due to certain reasons, petitioner could not, but due to certain reasons, petitioner decided not to join. Therefore, whether petitioner should get the benefit of extension of validity of recommendation in terms of proviso to Rule 17(3) of the West Bengal School Service Commission within bracket selection for appointment to the post of teachers for upper primary level of schools, close bracket Rules 2016, needs consideration by the concerned authority of the Commission. Next one. Petitioner, on being selected in first SLST 2016 upper primary, was recommended VDA memo dated 6 March 2025, but he could not join as it is submitted on behalf of the petitioner, as it was submitted on behalf of the petitioner that petitioner's father was ill. Stop. Petitioner made a prayer for extension of validity of recommendation, which was received by the Commission as it appears from page 28 of the writ petition on 30th June 2025. Next paragraph. Therefore, it appears petitioner did not approach the Commission within 90 days from the date of recommendation made, from the date of recommendation dated 6th March 2025. Stop. Extension of validity of recommendation is not a matter of course. It depends upon the decision to be taken by the concerned authority of Commission if it is found expedient. Next paragraph. Chairman, West Bengal Central School Service
There is a
Commission.
humble request, secretary may be directed, my lord.
Secretary's party.
Yes, ma'am, responding 5, my lord.
5.
Secretary West Bengal, Secretary of the Commission, being respondent number 5, is directed to decide prayer of the petitioner for extension of validity of recommendation by 4 weeks from the date of communication of this order. Stop. Decision to be taken by the respondent number 5 shall be communicated to the petitioner by 10 days thereafter. Stop. Stop. Next paragraph. Authorities are directed not to fill up the post in terms of the recommendation dated 6th March 2025 till decision is taken and decision is taken by the respondent number 5 and it is communicated to the petitioner. Next.
Item number 5.
I beg to appear for the state, my lord.
Retired, headmaster retired on 28th of August 2009. Despite all the fields of nothing happened.
When retired?
28th of February 2020.
20?
28th February 2020.
25
Yes.
from the post of headmaster.
Yes.
And he is not getting pension. Why? Is there any objection where the pension papers are lying?
I'm telling you.
You are for the state.
State.
Yes.
My lord, what happened, my lord? The JDA has issued some objections, my lord, and it was to be cured on the part of the HOI. Since my lord, he is himself was the headmaster and the post of headmaster was vacant, this could not be done by the school authority. However, my lord, the school authority asked the TIC to present in his office and cured all the objections.
School authority or DI?
DI asked the school authority, my lord, the present TIC, my lord, all objections have been cleared and it was sent to the JDA.
Very good.
And yesterday, JDA has sent it to the DPPG, my lord, with all, covering all
Based on your submission, I am directing the DPPG to
Yes.
issue pension payment order on compliance of formalities.
Yes, this is the
Can you be possible private time?
Yes, yes.
You
Here the court's order.
Yes, and your lords similarly placed on an employee. who was-
Please.
Yes,
Wait.
yes.
Who will send it to the DPPG?
yesterday at 4:30, my lord, it was sent to the DPPG. This is my specific instruction.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Matter relates to release of retirement dues including pension due to superannuation of the petitioner on 28 February 2025 from the post of headmaster. of Birlapur Vidyalaya, South 24 Parganas. Next paragraph, learned advocate representing the state respondents has filed a communication with a memo dated 20 August 2025 of the District Inspector of Schools AC South 24 Parganas and same is taken on record. From the said communication dated 20th August 2025, it appears that initially on submission of pension papers, certain objections were raised by the concerned Joint Director of Accounts, which were by the Joint Director of Accounts. Stop. Stop. School authority as well as District Inspector of Schools AC South 24 Parganas being respondent number 5 took steps to comply with those objections, and thereafter pension file was placed before the Joint Director of concerned Joint Director of Accounts, and it was found in order. Stop. It is submitted by the learned advocate representing the state respondents today on instruction that on 20th August 2025, pension file was forwarded to the Director of Pension, Provident Fund and Group Insurance for taking necessary steps. Next paragraph. Since by curing defects, pension case has already been submitted, or pension case was already submitted before the Director of Pension, Provident Fund and Group Insurance being respondent number 2 on 20 August 2025, respondent number 2 is directed to issue pension payment order by 3 weeks from date on compliance of necessary form. Stop. State respondents are directed to release retirement dues including pension in favor of the petitioner at an early date but not later than 8 weeks from the date of communication of this one. Stop. Writ petition stands disposed of. Next.
Item number 6.
Got the appear for the petitioner. His wife is admitted in hospital.
What happened to him?
Phone me, Mala. Seriously.
I am for the state.
In the night, yesterday night.
All on a sudden, he was doing the matter
Yes,
2 days back in this.
Day before yesterday.
Suddenly it was detected.
No. It was detected, the operation was done, that was successful. But comorbidities thereafter is developed.
Well, then
Not certainly. Next week.
2 weeks time, my lord.
at the time of call, accommodation is paid for on behalf of the petitioner. Since learned advocate is unwell, respondents are represented by learned advocates. Next paragraph. Hearing of this matter stands adjourned. List the matter under the same heading on
কিভাবে দিয়ে পাঠিয়ে দিই
11th September 2025.
এটা অল্প
Yes.
item number 7.
It is also decided by the Honorable Supreme Court. I relax his 2016 selection, my lord. Now I'm
It's already decided by this court, then division wins, then nothing remains. I have challenged the notification dated 30th May 2025. Where is that notification? Yes, yes. Sanjay Doloi. Sanjay Doloi.
Sanjay Dili, thereafter division bench, there was an order and
page 55.
Page 54.
55.
Petition. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. In the writ petition, West Bengal School Service Commission within bracket selection for appointment to the posts of assistant teachers for upper primary level of classes. Again within bracket except work education and physical education. Close bracket, comma, classes 9, 10 and classes 11 and 12. Close bracket. Rules 2025. Page 55. Yeah? Rules 2025 is questioned. Stop. However, issue is no more recently grasped. In view of the judgment delivered by this court, delivered by this court on 7 July 2025 on a batch of writ petitions, first one being WPA 12505 of 2025, Sanjay Kumar Doloi and another versus the state of West Bengal and others. Close bracket. Matter traveled up to Supreme Court, but order of this issue traveled up to Supreme Court. Issue traveled up to Supreme Court. Traveled up to the Honorable Supreme Court, but the judgment delivered by this court was not interfered with. Stop. Next one. Hence, no relief can be granted to the petitioner. Writ petition stands dismissed. Rajendra. Do you want to take it back? I have a copy.
as your lordship, if it is required, my lord, keep.
No, I have copy.
Item number 8.
My lord, the working in 19 and my lord, he lost the job in terms of the order passed by the Honorable Supreme Court. The petitioner, my lord, selected in the two selection process in my lord, the upper primary physical education, work education, and SLST 19 for the subject geography. In that work education, my lord, they have issued the my lord, the recommendation letter, but already he had not joined because he already joined in the 19 school in terms of SLST 2016. But in the meantime, he lost the job. He made application before the School Service Commission to consider the matter in terms of the Supreme Court passed the order in paragraph 47. Considering the paragraph 47, this representation is pending before the School Service Commission. But yesterday, your lordship asked me whether the panel is in the 2019. The panel was published, but the validity panel expired within the 1 year. However, 2022, the government decided to extend the lifetime of the panel, and till this panel has been valid, and my lord, 1600 waitlisted candidate waiting for the appointment. And this issue is pending before the another learned honorable coordinate bench.
Show me any document that this panel, which expired on 12 December 2018, or which expired on 11 December 2019, was subsequently extended.
This is the, my lord, the notification.
relating to creation of supernumerary
Yes,
posts.
yes, that is the
Yes.
state candidate, extended the panel, the 1600 candidates already waiting for the appointment.
প্যানেলে লাইফ এক্সটেন্ড হয়েছে লিখেছে
Waiting list candidate still waiting for the appointment. Yes.
It is for accommodating wait-listed candidates. You are not the wait-listed
I am
candidates.
the impanel candidate.
You
but
are
selection
impanel
process
candidate,
is-
but you did not join the post.
Selection process is still continuing.
No,
That is
no.
my prayer. Yes, yes, that is they have issued the interim order to not to allow to join anybody.
That is to accommodate wait-listed candidates.
Waitlisted candidate.
You are
means
the impanel candidates, but you did not join since you are working in another school.
question report.
How you can be, your case is akin to the case of the wait-listed
The
candidates.
subject to lordship person question is before the honorable coordinate bench whether the lifetime of the panel is expired or not. That is under sub judice.
That I do not know. I would
Malad,
follow
this
the
is- Malad,
law
this-
relating expiry
No,
of
this is
panel.
but Supreme Court already, the 8th April 2025, the passed an order. This memo is the valid and consider that issue, this bench, coordinate bench is decided the issue. Learned advocate on behalf of the School Service Commission, the made an affidavit.
What was decided by the court?
Well, they have issued the interim order, interim protection, selection process going on, not to allow anybody to join in the said selection process who have got the recommendation letter. But this is the
In
order.
which selection process?
This selection process, 2016, work education visibility. Meenakshi Ghosh.
Is what is submitting?
My lord, if
Malad,
my learned friend should make very clear-cut arguments. Simply, suddenly mentioning coordinate bench, mentioning Supreme Court, it will get us nowhere. What is the real situation? He was a candidate for work education. He was recommended. He did not join. My panel, it was published on 12/12/2018 and it expired on 11/12/2019. That is the end of the story as far as the petitioner is concerned. Now, when the panel expired, by then we had concluded the panel, recommendation of the panel, and as far as the waitlist could have gone, all vacancies exhausted. Subsequently, government took a decision
To create
supernumerary post for accommodating only the waitlisted candidates, the leftover waitlisted candidates, not for all candidates, not for absentee candidates, not for empaneled candidates, not for other waitlisted, only for those who did not get employment. Due to the dearth of the vacancies got exhausted. That is under challenge. Undisputedly, that is under challenge by the coordinate bench, that whether in this situation the government was right in creating the supernumerary post or not. So that part has nothing to do with this candidate. As far as this candidate is concerned, the panel has expired in 2019, December 2019, and he sat tight over his recommendation because he was working elsewhere. So as on date, he cannot be accommodated in any manner in any issue. Please.
The last year lordship passed this order.
910.
Yes. 910 had lost.
910 or 11, 12?
910.
910. Second page, my lord.
Work education should, right?
recommendation.
জব লুজ করেছিল 3rd April।
January 20.
But I have not decided this. Matter was
This is-
directed to
this is-
appear under the heading motion.
Yes, that
I
is-
was only directed to take the instruction,
because
and what is recorded is my learned friend's submission.
I have full sympathy, but the problem is that these stages are over. What can be done today?
In terms of paragraph 47, hospitals give very praise within 3 years.
Affidavit of no, affidavit of file your affidavit of service. Affidavit of service filed on behalf of the petitioner is taken on record. Petitioner participated in first state level selection test 2016 for classes 9 and 10, and also for upper primary level of, and also for first SLST 2016 for upper primary level of classes in connection with work education and physical education for being appointed as assistant teacher. Petitioner selected in both the selection processes, but decided to accept appointment in connection with petitioner's participation in first SLST 2016 for classes 9 and 10. You did not participate in the counseling in your favor in connection with work education, physical education. Therefore, in spite of being recommended for being appointed as assistant teacher, in connection with first SLST 2016 upper primary for work education and physical education, he did not join the post. So, petitioner prays for direction which would permit the petitioner to join the post of assistant teacher of work education, assistant teacher of work education for upper primary level of classes, since petitioner has lost job in terms of the judgment of the Honorable Supreme Court dated 3rd April 2025, passed on civil appeal arising out of special leave petition civil numbers 9586 of 2025 within bracket State of West Bengal versus Boipaki Bhattacharya Chatterjee and others close bracket. Next paragraph. Now, stop. Next paragraph. Petitioner also relies upon. Now, client advocate representing the petitioner relies upon an order dated 19th May 2022 issued by the Deputy Secretary to the Government of West Bengal, whereby decision was taken to create supernumerary posts to accommodate waitlisted candidates. In connection with waitlisted candidates, in connection with first SLST 2016 upper primary work education physical education. It is submitted that issue is pending. It is submitted that validity of the said order dated 19th May 2022 issued by the Deputy Secretary is still under consideration by a coordinate bench. Therefore, petitioner, therefore it is not a case that panel which was prepared on completion of first SLST 2016 upper primary work education and physical education expired. Next paragraph. West Bengal Central School Service Commission is represented by learned advocate who submits that petitioner is not waitlisted candidate. Therefore, he is not entitled to get the benefit of the aforesaid order dated 19th May 2022. Stop. Furthermore, panel which was prepared in connection with first SLST 2016 upper primary work education physical education expired on 11 December 2019. Next paragraph. It appears that petitioner lost job in terms of the judgment dated 3rd April 2025 passed by the Honorable Supreme Court in Boishaki Bhattacharya Chatterjee Supra. And petitioner, when recommended for and petitioner ta kete dao, when recommended for and at the material point of time, petitioner did not join the post of assistant teacher in work education for upper primary level of classes, since petitioner was working as an assistant teacher for classes 9 and 10. On being selected in first SLST 2016 for classes 9 and 10. Meanwhile, panel which was prepared based on first SLST 2016 upper primary for first SLST 2016 upper primary work education and physical education expired on 11 December 2019. So, subsequently, order dated 19th May 2022 was issued by the Deputy Secretary in order to accommodate waitlisted candidates by creating supernumerary posts. Stop. Indisputably, petitioner is not waitlisted candidate. Stop. It is also fact that the panel relating to first SLST 2016 upper primary work education and physical education expired on 11 December 2019. Next paragraph. It is straight law that after expiry of the panel, candidate loses right to claim appointment being a selected candidate. Stop. In this regard, reliance is placed on the judgments of the Honorable Supreme Court dated Honorable Supreme Court reported in 1996 9 SSC 309 State of Uttar Pradesh and others versus Harish Chandra and others, and another reported in 2009 to SSC 706 Girdhar Kumar Dadhij and another versus State of Rajasthan and others. Next one. Hence, no relief can be granted to the petitioner. Writ petition stands dismissed. Urgent certificate. Okay.
Item number 9.
My lord, I pay for respondent numbers 1, 2, and 3.
It's true. Certificate instead of biological. Birth certificate I have annexed initially. It was
Petitioner son is working, reading where? Studying where?
ICSE board.
In which class?
He has passed the school ballot. He has passed.
Yes.
Secondary education he has passed.
Class 10 he has passed.
Yes.
When this adoption took place?
It was in 2008.
So why timely steps was not taken? Were not taken?
In educational certificate, it has not been done, but in other cards, ID cards, in that manner,
Now the student is studying in where? In which student
he is not studying. Study is not his.
So the student has come up.
Yes, student.
Yes. What is the prayer for changing names of the parents?
So for my application before the school authorities, the university, that was made. 4 instructions have come from them. First instruction, will come at page 47. Page 47, their instruction is I am to submit this document, attested copy of birth certificate with correct values, newspaper clipping, affidavit of from the.
So what are the documents where these corrections are required?
That is fourth. They have demanded now on the 4th instruction at page 65. They have asked for court direction, court order at page 65. Kindly upload the following documents and resubmit the request. Upload the copy of the court order decree. Therefore, I have filed this writ petition. And second is, please upload the gazette notification stating the change parent's name along with.
So you file the court order relating to adoption.
Now the adoptive parents are not alive; they have died. But the registered deed is there. Registered deed is there on the basis of the registered deed, in the Aadhaar card as well as the voter ID card. Names have been changed. The adoptive parents' name have been recorded. When I made the application before the school of the educational authorities, they are saying on 4 times, they have asked for different documents.
So you are not in a position to submit court order decree.
No. Court order, therefore I have come to the lords. My lord may permit me to change the name. Okay.
So why court orders are not there?
But actually registered deed is sufficient. Nobody is disputing that. The biological parents are not disputing that. The daughter is not disputing that. But no objection is there.
Daughter means?
He is the petitioner before the lords.
Where is your registered deed?
In the office records of the mother, my lord.
Where is your registered deed?
Registered deed is it at page, my lord? 18. Page 44, my lord, will find the.
When you passed class 10 examination?
My lord, I have annexed document. Please, my lord. page 45. Is my lord 2017. In this document, my lord, the biological parents' names are there. R. Sujata is the mother's name, and R. S. Rao is my lord, the adopted father's name. Biological father's name. These two names are required to be correct.
R. Sujata and R. Iswara Rao are the biological parents.
Biological parents. Page 44, in the deed, my lord, you'll get 4 of them. Biological parents and my lord, the adoptive parents. First two are my lord.
Now it is R. Venkat Rao and R. Sarala.
Sarala.
So why based on this adoption deed you are not doing this?
Just two small submission, my lord. See this analogy. A sells a property to B, B to C, C to D. What is to be seen is the chain is not broken. A's deed is not changed. My lord, those were recorded unless, my lord, I have some sort of, my lord, protection.
What protection?
My lord, a court order, I cannot change it ipsi dixit like this, my lord. The name at the relevant point of time was this. Today, my lord,
No. Do you find any material based on which this deed of adoption can be questioned?
No, my lord, I'm not discounting that for a moment. And in fact, I'm not resisting for the sake of resisting. My lord, the procedure part is, my lord, the first sale deed, this analogy, the name of the vendor is never changed. One has to show the chain deeds. This is what it is.
So this is the deed.
My lord, therefore,
It's not a vending process.
Example I'm giving. Therefore, what has happened is
There is no mother deed. There is no present deed. Only one adoption deed.
No. The nursing home papers, the birth certificate would be the parent deed. Well, parent's name, the natural parent's name would be there. Now, that is there. That was correct at that point of time. The problem which has arisen,
and already in other documents like Aadhaar and
yes,
birth certificate has also been issued recording the adoptive parents' names.
Where the shoe is pinching, they apply to the railways for the job. The railways is saying that you get that change instead of considering this deed, the adoption deed, because
they
are not considering this, my lord. Railways has to see this is it. The natural parents were so and so. Now they have been adopted. This is the name of the parents, my lord. This doesn't require the change in the original deed, my lord.
No, what railway is saying?
Railway is saying, my lord, the educational certificates, name of the biological parents are there. It should be, my lord, adoptive parents. All other documents
of time.
Do it.
I will, my lord. I will buy down to your lordship. But, my lord, unless I am protected by a lordship's order, my lord, if I do it, I don't know on what basis I would be doing it.
In page 65, they have prayed for court's order and then, my lord, gazette notification.
This was, my lord, the other formalities they may comply after your lordship passes an order.
Not for the change of parents, it is not his name.
No, I will direct the council to incorporate names of the biological adopted parents in place of biological parents based on this adoption, because they are also facing problem. Because the order is not there and the gazette notification is not there, and you will not get service on the other end unless until these certificates are amended.
Well, yes, actually the railways should have considered. The chain is complete. They should have considered the adoption deed and accordingly, my lord, granted.
Adoption deed is sufficient.
Yes, my lord.
Unless and until it is questioned.
My lord, if it is sufficient, it doesn't have to relate back to the date of birth and change the deed, the birth deed.
Yes,
it's complete. It's complete in itself. It's complete in itself.
Affidavit service filed on behalf of the petitioner is taken on record. Stop. Petitioner prays for direction upon the Council for Indian School Certificate Examination, comma, New Delhi, within bracket hereinafter referred to as council, quote unquote, close bracket,
May I have your lordship's leave, my lord? I'm grateful.
for correction of only this certificate at page 45.
45, 46.
Class 10 and class 10 plus 2,
No, my lord, same certificate. Yeah, one is mark sheet, one is certificate.
statement of marks.
Yes.
Correction of, for correction of birth certificate and mark sheet, or correction of birth certificate and statement of marks which were issued for petitioners' participation in Indian Certificate of Secondary Education within bracket class 10 examination held in 2017. Petitioner's biological father, petitioner's biological parents were Srimati R. Sujata and Sri R. Iswara Rao, page 45 এ পাবে, দাগ মারা আছে। Whereas petitioner's adopted parents are Srimati R. Sarola and R. Venkata Rao, page 19. Stop. In the mark sheet, in the birth certificate and statement of marks relating to Indian Certificate of Secondary Education within bracket class 10 Roman 2017, names of biological parents are there, and petitioner prays for incorporation of names of parents as per adoption deed dated 26th March 2008. Comma, they are Srimati R. Sarola and R. Venkata. Next paragraph. Council is represented by Mr. Bag, the learned advocate, who submits that steps were taken for correcting aforesaid two documents, but due to want of certain documents, process could not be made complete. And in this regard, reliance is placed on the document at page 65 of the writ petition. Next paragraph. On perusal of the writ petition, it appears adoption deed was executed on 26th March 2008, and by virtue of same, Srimati R. Sarola and Sri R. Venkata Rao became adopted parents, became adopting parents of the petitioner instead of her biological parents, Srimati R. Sujata and R. Ishwara. Stop. There is nothing on record which goes to show that this adoption deed dated 26th March 2008 is questioned from any corner. Stop. Next paragraph, it further appears in your income tax, PAN card and Aadhaar card, name of the adopting parents are there.
Voter ID. PAN card, my lord, I have applied for dismissal.
But father's name is, just a minute. Or which one? In PAN card, biological father's name is there.
Yes, I have applied for dismissal.
Where is the voter card and PAN and Aadhaar card?
Right, page.
Page 30 is voter card.
Yes, we did 33 is my lord. Voter ID card, 33. And my next page, 34 is Aadhaar card. And my lord, D. Sarola, mother's name is R. Sarola, mother's name has been recorded.
Page 33 is voter ID card.
Yes,
And page
34 is the Aadhaar card.
page 34, where are the names of your parents?
Page 34, immediately after name, 2K R Kapo, then my lord, D.O. R Sarola. R Sarola is the mother.
R Kabba at the bottom of page 34.
No, my lord, immediately after Unique Identification Authority of India, enrollment number, at the top, my lord. Then,
Oh, dotted out.
yes. R Sarola.
R Sarola. R Sarola. কি বলছিলাম? It further appears from voters identity card and Aadhaar card of the petitioner, name of adopting mother has been incorporated. So, next one. Hence, concerned authority of the council is directed to correct pass certificate and statement of marks is directed to correct the documents, namely pass certificate and statement of marks, in connection with petitioner's participation in Indian Certificate of Secondary Education within bracket class 10 2017 examination, thereby expunging name of biological biological parents and incorporate names of parents in terms of incorporating names of adoptive father and mother, সব জায়গায় adoptive করে দেবে, হ্যাঁ, IVE, adoptive father and mother in terms of deed of adoption dated 26th March 2008. Within a period of 4 weeks from the date of communication of this order, and to issue fresh pass certificate and statement of marks within the aforesaid time. Next paragraph, writ petition stands disposed of by the Xerox submit. Adoptive করে দিবে, adopting টা correct হচ্ছে না, adoptive
Item number 10.
Why? What is the matter about?
My lord, matter relates to extension of validity of the recommendation, my lord. Petitioner made prayer before the commission. Commission extended for 1 month. Thereafter, she again made an application for further extension of 3 months.
3 months.
My lord, recommendation was issued on
An instruction. Very well. I am placing it in the next week. Next week. I am fixing a date. Oh no. At the time of call, accommodation is prayed for on behalf of the petitioner. However, respondents are represented by learned advocates. However, state respondents and West Bengal Central School Service Commission are represented by learned advocates. Stop. List the matter under the same heading on
September first week or processing.
2nd of September 2025. Next. Next.
Item number 11.
Lordship, in this matter, Miss Pona Roy Choudhury appearing before State Lordship. I am led by Miss Roy Choudhury. She has
Who is
Miss Pona Roy Choudhury. I am led by Miss Roy. She has engaged court room 33. I am praying for passover, Lordship.
Not today. Next.
Item number 12.
Respondent number 6, madam.
Group D staff from the year 2009, man. Thereafter, he superannuated from service in the year 2000.
Group D staff?
Group D staff at Bankura Town Girls High School, my lord, since the year 2009. Thereafter, his appointment was approved from time to time. Thereafter, he superannuated from service in the year 2024, my lord. Thereafter, after my lord superannuation, my lord, I have made repeated representations before the school concern for sending the pension papers before the concerned authority. But till date, my lord, no steps have
When retired?
my lord, in the my lord,
Clerk.
my lord, Group D staff.
Group D.
Staff, my lord, retired on 30th of September 2024. 2024.
Yes,
My lord,
but you are not getting pension and other benefits.
Thereafter,
Where the pension papers are lying?
my lord, before the school authorities, my lord, thereafter I made representation before the DI concern, my lord, wide memo dated Now kindly comes to page
15.
my lord, page 15, annexure P2, my lord. The DI of schools Bankura, my lord, wrote to the my lord headmaster of the institution, my lord. It is observed that pension file of Lalmohan Bauri, retired employee of his or her school, are not received from his or her end to this end for a long period, though the teacher retired in the month of September 2024. Under these circumstances, you are requested to take necessary action as per Geo dated such and such. Otherwise, he or she will be solely responsible for non-payment of retirement benefit of the retired employee. Thereafter, my lord, I made representation to the school authority, but
It says though the teacher retired.
though the teacher retired in the month.
Petitioner is Group D.
Group D, my
Wrongly stated.
wrongly stated. Thereafter, my lord, I made representation.
Just a minute, just a minute. You are appearing for the state.
My lord, I am preparing for the state, my lord.
Who is for the school?
I am for the school. My teacher.
Why this has not been followed?
Kindly see the page 13, my lord. Approval letter, my lord.
Yes.
Page 13, my lord, approval. My difficulty is,
Approval.
yes, my lord. My difficulty is, my lord, I am not standing in the way, my lord. The approval,
Page 13.
yes, my lord. Approval letter, my lord. Left hand side, my lord. The approval of the appointment to the approve of the condition which will be abide by the W number suggestion pending before the Honorable High Court, Calcutta, my lord. This is a specific direction with that, like,
Petitioner has retired after completing service and he will not get pension.
yes, my lord, this.
Forward it immediately within 7 days.
Yes, my lord. Given direction. My lord.
Forward it immediately within 7 days.
Kindly, my lord.
Otherwise, I will stop the payment of the teacher in charge or headmaster.
Kindly 2 weeks, my lord. Not 7,
No,
2 weeks.
issue.
10 days at least, my lord.
No ground at all. The person has already completed the
This is my difficulty,
completed,
my lord. I am not standing in the way, my lord.
and reached the age of superannuation and he will not get pension subject to since this is a conditional approval due to pendency of 2007 writ petition. I will direct the authorities that subject to result of 2007 writ petition release the entire benefits. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner being Group D staff of
Bankura Town Girls High School.
Bankura Town Girls High School, Bankura, retired on superannuation on 30th September 2024. Grievance of the petitioner is in spite of grievance of the petitioner is even after retirement on 30th September 2025 till date, pension papers have not been forwarded by the school authority to the District Inspector of Schools AC Bankura, being respondent number 4. Stop. Notice of this court has been drawn to a memo dated 11th February 2025 issued by respondent number 4, whereby school authority was requested to forward pension case of the petitioner at an early date. Stop. Next paragraph. School authority is represented by learned advocate who submits that due to conditional approval granted in favor of the petitioner by the District Inspector of Schools, by the respondent number 4, with a memo dated 9th November 2009, pension case till date has not been forwarded. Next paragraph. It appears that petitioner on being appointed as Group D staff on 19th August 2009 has completed his service period on attaining age of superannuation on 30th September 2024. Therefore, petitioner is entitled to receive retirement dues including pension. Next paragraph. Teacher in charge of Bankura Town Girls High School, being respondent number 6, is directed to forward pension papers of the petitioner upon completing the same in offline mode by 7 days from date by 7 days from this date.
10 days.
Stop. On receipt of pension papers, the respondent number 4 shall take necessary steps for settling the pension case in accordance with law and at an early date. And at an early date, stop. Respondent number 4 is directed to submit a report before this court disclosing the steps taken in this disclosing the steps taken for settling pension case of the petitioner, comma, on the next day. List the matter under the same heading on. September 2025.
But can we 10 days, my lord?
It will be a loss. Yes, call the reason.
Item number 13.
For the school, my lord, respond number 5.
Although I'm led by Mr. Shoma Mujumdar, if your lordship kindly allows me to place the matter.
Yes.
The petitioner before your lordship is an assistant teacher who was appointed in the year of 2010. My lord, in 2025.
Louder, please.
I'm sorry, my lord. The petitioner before your lordship was appointed.
2010 appointed, yes.
My lord, she has prayed for transfer on the ground that her husband resides in Holdia and she is working presently in Jhargram. But the distance between these two places is 165 kilometers. But she has two children, my lord. One is of 15 years and one is of 3 years, my lord. And her father-in-law is suffering from cancer. Now, my lord, the distance between these two places, my lord, is causing great difficulty for her, my lord, to render her duties as a teacher in this school. When an application was made through proper channel, my lord, that application is.
When application was made?
When the application, your lordship would find, my lord, at page, my lord.
Who is appearing for the commission?
It's pending at the end has not been forwarded by the school till date, my lord. So it is.
But it will ultimately reach the commission.
Yes.
The commission has to be made party.
Commission is
School Service Commission. Who is appearing for the school authority?
Lord, I am appearing.
He is appearing for the school authority.
Where is your application?
Yes. Your lordship kindly comes to my lord page
26.
24. It's my lord, the application through proper channel, my lord. And
This is not an application in prescribed format.
yes, prescribed format, your lordship would find at page 28, my lord.
What is the date of application?
56.
It is, my lord, dated, my lord. It was submitted along with, my lord, the representation that your lordship would find at page 24, my lord. 14th of July, no, it's my lord, 5th of June 2025.
5th of June to the school, but I don't know, my lord, which signature is. This is 14th July is written. Oh,
At 27, your lordship would find, my lord, the seal of the school indicating the date, my lord, 5th of June 2025.
Now, what is the ground for transfer?
Now, the grounds for transfer is if your lordship kindly comes to my lord.
Because the distance, husband is working at a distance that cannot be a ground under the rules.
But if your lordship kindly comes to my lord page.
Either it will be on the ground of distance in between the present school or in between the two schools. If it is
But if your
higher than 25 kilometers,
page 17 of
then you can pray for transfer. And otherwise, if there is a distance ground is there in between the present school of the petitioner and petitioner's place of residence,
it is
otherwise on
160.
medical ground or other grounds as contemplated under the rules.
But if your lordship.
So is it on medical ground application or on the ground of distance?
Distance.
Distance ground. Now, why the school authority is not giving no objection?
My lord, first of all, my lord, he is residing nearing the school, my lord, but he is claiming that he is residing in the pattern.
On rental accommodation.
On rental accommodation, he is residing, my lord.
No, where is her permanent residence?
Holdia.
That is important.
Holdia.
Because if her permanent residence is at Holdia, then she has to arrange an accommodation at Jhargram. Otherwise, she won't be able to attend the school.
25 kilometers more.
It's not possible for a person to attend the school regularly at 10:30 a.m. in the morning by starting at Holdia. So therefore, he has done the right thing by taking an accommodation on rent. But that does not obliterate petitioner's right to get transferred if she is otherwise eligible. So apart from this, why the school authority is not giving no objection?
This is the first, my lord. Second thing is that, my lord, there are more than 300 students in his subject in the school.
Whether the petitioner is a single teacher in the subject?
Teacher in the school. But kindly see
what is the subject of the petition?
Education.
Education in higher secondary school.
Kindly see the resolution, my lord.
Then there is a difficulty.
Kindly see the resolution.
Local arrangement is made.
It has to be made, my lord.
You won't get.
But there's a judgment, I believe, in Payal Goswami, perhaps your lordship is aware, where the direction was passed that
very well, you grant no objection. Being a single teacher and DI will take steps in accordance with a 3rd January 2022 notification. But you have to forward it. You cannot keep this transfer application with lying in the chamber
Well,
of
it's
the
not
headmaster.
giving, my lord. Actually, my lord, the managing committee on their resolution actually rejected the application.
How? They are not empowered.
But
to.
I told them, my lord, that this is wrong.
How this rejection
The
can be
decision
done?
was taken, my lord.
If alternative arrangement is made in the school, then petitioner would be transferred. Issue.
Page 29 mention 165 kilometers from the permanent residence.
Yes, permanent
But
residence
itself
is
it is there.
He has,
could have placed
he has
this-
taken the right step
Yes.
by making an arrangement of accommodation at Jhargram.
Hmm.
Otherwise, it is
Need
not
to have a
possible
list.
for her to attend the school regularly.
Page 29. Mention in the form.
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner. Prayed for transfer in prescribed pro forma on the ground of distance in between the present school of the petitioner and her place of residence. Stop. Transfer application was made in offline mode on 5th June 2025, but the grievance of the petitioner is till date authority of Rohini CRD High School within bracket HS Jhargram being respondent number 5 has not issued no objection. Next paragraph. Lied advocate representing the school authority submits that by adopting resolution dated 4th July 2025, managing committee of the school decided not to grant no objection on the transfer application of the petitioner, since there is robust role strength in the school and petitioner is single teacher in the subject in higher secondary section. Stop. Next paragraph. Learned advocates representing the state respondents and board have jointly submitted that if petitioner is found to be a single teacher in the subject in the school, transfer application needs to be forwarded to the concerned district inspector of schools, SC, Jhargram, being respondent number. But you have made Paschim Medinipur as party.
We have to add because there was a miscommunication. My lord, we thought Paschim Medinipur is the actual authority. If your lordship
District
grants me
inspector of
leave, my
schools,
lord,
AC Jhargram. কি বলছিলাম?
দুটোকেই পার্টি
না, AC Jhargram. Stop. Stop দিও না. In terms of the government notification dated 3rd January 2022. Stop. Next paragraph. If petitioner is stop. It is rightly it is rightly pointed out on behalf of state respondents and board that if applicant teacher is found to be a single teacher in the subject in the school, school authority is required to forward transfer application to the concerned district inspector of schools AC for taking steps in terms of notification, government notification dated 3rd January 2022. If said applicant teacher is otherwise eligible to get transferred on the ground of distance. Stop. Hence, district inspector of schools AC Jhargram is directed to forward transfer application. Hence, Secretary of Managing Committee of Rohini CRD High School being respondent 5 is directed to forward transfer application of the petitioner to the district inspector of schools AC Jhargram by fortnight from the date of communication of this order. Stop. On receipt of transfer application, concerned District Inspector of Schools, AC, shall make an endeavor to find out willing teacher from neighboring schools who can man the post of the petitioner if petitioner is transferred. Stop. If willing teacher is found from neighboring school, petitioner shall be transferred immediately thereafter in accordance with law. Stop. Writ petition stands disposed of. Now, next paragraph follow. Leave is granted to the learned advocate for the petitioner to amend the cause title in courts of this day and describe respondent authority against describe authority against respondent number 3 appropriately. Stop. However, service of notice upon District Inspector of Schools AC Jhargram is dispensed with since state respondents are represented by learned.
I'm grateful.
Next paragraph, writ petition stands disposed of by the Xerox certificate.
Great.
সবাই একটু নাম দেবে না
Item number 14, Millard, the issue has already been.
Sir, the item I'm praying for not today because my
Boisaki Bhattacharya, age relaxation, they sought for, his lordship has decided, travel to Supreme Court, affirmed.
I am praying for not today because my senior is engaged in another court. Kindly grant a not today.
Well, not to do. As prayed for, record an order. As prayed for on, dekhi. As prayed for on behalf of the petitioners, hearing of this matter stands adjourned. However, state respondents and board are represented by learned advocates. Next paragraph. List the matter under the same heading on Monday next, 25th August 2025 for further consideration. Stop. However, no further adjournment shall be done. Next.
Item number 15.
This is also I'm praying for not today.
Same issue.
Petitioners or single petitioner?
No, Millard, here, Millard, and others, yes.
Petitioners.
Same order. Monday.
Get foolish.
Item number 16.
Page 23. In page form.
School has granted no objection.
Yes.
Now, where the application is lying?
But lordship, as per my lordship information, lordship, school authority lordship not served, copy has been not served to the lordship DI. Matter is
Not
pending.
forwarded to the DI.
No forwarded DI.
But no objection has been granted.
Yes, no objection has been granted and school say I am forward the letter to the Lord DI. Kindly see the page 22.
It's an application on distance ground.
Distance.
So let it be forwarded to the DI and there are
Yes,
the council and commission to take
Yes.
decision.
School authority may be directed.
Maybe direction to the school authority to the lordship.
When this application was made,
Application was made lordship on,
because school authorities, no objection is undated.
yes, that lordship 25. 10th board lordship.
Page Millard, 22, Millard.
10th April.
April.
Forwarded to the DI.
DI.
But
But
DI
Mr.
did not
Bushra is
got
submitting that it has not been forwarded.
Forwarded to the district for new inspectors.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner made an application for transfer on general ground within bracket distance on 10th April 2025, and the school authority where petitioner is presently working issued no objection on such transfer application. It is also submitted on behalf of the petitioner that transfer application was forwarded by the school authority to the District Inspector of Schools AC Poschim Medinipur, being respondent number 9. However, such submission is disputed by Mr. Boisho, learned additional government pleader representing the state respondents. So, it is submitted on behalf of the state respondents that school authority has not forwarded transfer application. As a result, whereof steps could not be taken on transfer on said transfer application. Next. The board and West Bengal Central School Service Commissioner represented by learned advocate. Next. Respondent number 10 is directed to forward transfer application of the petitioner to the respondent number 9 by 7 days from date of communication of this order, if till date transfer application has not been forwarded to respondent number 9 by the school authority. So, on receipt of transfer application, same shall be processed by the respondent number 9 by fortnight thereafter, and forward the same, and shall forward the same to the 6 Secretary, West Bengal Central School Service Commission, being respondent number 6. By 7 days thereafter. Next one. On receipt of transfer application, respondent number 6 shall decide the same in accordance with law by 8 weeks from the date of communication of this order. By 8 weeks thereafter, and decision to be communicated to the petitioner by 10 days thereafter. Next paragraph. It is made clear that entire process shall be completed in offline mode, and suspension of portal shall not be a ground to reject transfer application. Stop. Next paragraph. Writ petition stands disposed of or then
Agreed.
Next.
Item number 17.
It is the transfer of distance from online transfer application. It is pending before the commission. My transfer application. This is the status. Page 180. It is general transfer application pending before the commission. 10th of February 2022, date of application. It has been forwarded to 21st of February 2022.
It is application dated 10th February 2022.
Yes.
We have forwarded in 2022.
Which for the commission?
For the commission.
General transfer application, let it be decided.
Yes.
Old application, right?
Yes. 3.5
But
years.
it is not application on medical ground. So further examination on medical examination is not required at all. So let it be. Perhaps the commission has not taken decision due to suspension of portal. Issue. Affidavit of service filed on behalf of the petitioner is taken up. Petitioner made an application for transfer on SOC portal on 10th February 2022. Stop. School authority where petitioner is presently working forwarded the transfer application to the concerned District Inspector of Schools AC on 9th February 2022. And District Inspector of Schools in his turn processed the transfer application and forwarded the same through portal to the West Bengal Central School Service Commission for taking decision. Stop. Grievance of the petitioner is still dead. Transfer application is not decided. Next paragraph. Respondents are represented by learned advocates who have submitted, perhaps due to suspension of portal with effect from 29 September 2022. Transfer application could not be, transfer application was not contemporaneously decided. Next paragraph. However, it is submitted on behalf of the Commission. If concerned authority is directed, transfer application shall be decided in accordance with law. Next paragraph. Having considered the submissions made on behalf of the parties, writ petition stands disposed of, directing whether secretary is made party.
Chair, respond number.
Direct the secretary. You make secretary party.
Or we are competent.
Directing the concerned authority of West Bengal Central School Service Commission. But there is a problem. If contempt application is taken out, then you will be with suit.
Not I shall. I shall.
Directing the Secretary West Bengal Central School Service Commission to decide the transfer application of the petitioner by 6 weeks from the date of communication of this order. Stop. The decision to be taken by the secretary shall be communicated to the petitioner by fortnight thereafter. Next paragraph, it is made clear that suspension of portal shall not be a ground to reject transfer application of the petitioner. Next paragraph, leave is granted to the learned advocate for the petitioner to amend the cost item in course of this day and add Secretary West Bengal Central School Service Commission as additional respondent. Stop. However, service of notice upon additional respondent stands dispensed with since Commission is represented by learned advocate. Next paragraph, writ petition stands disposed of or danger of
Only one observation is subject to correction. Can it be possible to decide my transfer action as per amended rules?
No, certainly not. Writ petition is dismissed. Leave is granted to the learned advocate to make a fresh application.
No.
এটা অ্যামেন্ডমেন্টটা করে নেব।
Item number 18.
State respondents.
Petitioner is the non-pitching staff, group staff, for mutual transfer.
Mutual transfer.
Portal
By single petitioner. Mutual transfer.
He was made
Filed by both the petitioners.
He was made as a
Both the applicant
He
teachers.
was made as a respondent. He was made as a respondent
So what is your grievance?
for mutual transfer.
Yes.
Page 17 and 18. 18 is the application of the petitioner. 17 is the application of the respondent.
Which respondent number?
Respondent.
The respondent number 8.
17 is petitioner's application.
Yes.
No, 17. 18 is the
18.
petitioner. 17 is the
18 is petitioner's application.
Fine. Under proceeding.
has been showing under.
Now, what is your grievance?
For mutual transfer.
So you both have applied for mutual transfer.
They have accepted each other,
but it has not been decided by the commission. Who is appearing for the commission? Have you made commission as party?
Central Commission not made party.
Then commission has to be made party. Commission has to serve.
Just now.
Issue. Take back your affidavit of service.
This is on the process.
Matter relates to mutual transfer, but West Bengal Central School Service Commission has not been made party. Leave is granted to the learned advocate to amend the constitution and add Secretary West Bengal Central School Service Commission and add West Bengal Central School Service Commission and its secretary as party respondents or as additional respondents in course of this day. So after such amendment is carried out, learned advocate for the petitioner is directed to serve notice enclosing copy of this order and copy of this writ petition upon Mr. Sunit Kumar Rai, learned advocate, who usually represents state respondents. Stop.
The commission, well, it's state respondents.
Concerned authority, who usually represents commission.
Fine.
Stop. Concerned authority of the commission is directed to regularize engagement of Mr. Sunit Kumar Rai on behalf of commission. Stop. List the matter under the same heading on August 2025. Grateful to 27.
27 Didi, 27.
Amend the cost title and then serve notice.
Item number 19.
Since around counter application pending before.
Dismiss. No condition to be attached. When application was filed in 2021?
2020.
1 year later, not in 2021.
Yes.
On which ground?
Distance.
Distance.
But it is true, well, previously petitioner applied on medical ground. It has been not 6 notified disease. It has been turned down.
Then you change the path.
But general ground, my lord, I can at any time, my lord, this is my strategy.
That can be done at any point. Whenever other applications are rejected, then general ground is there.
Disease.
Your application is dated 5th December 2022.
2022, reached to the commission 28 December.
5th December.
December 2022.
And it was sent to the commission on 28 December 2022.
Yes.
29 September to suspended.
Whether secretary is party?
No, chairman.
But the application was made, my lord, during the period of suspension of the portal.
This portal at that time, my lord, portal.
So, my lord, liberty may be given to the petitioner to apply afresh. 29th September, my lord, portal was suspended.
My lord, 31st up to 31st December 2022, any applicant can put their application, any distance. So subsequently, my lord, it has diverted to any. Your lordship can record my submission. It is my specific information.
And that is not a ground suspension.
First time it has been suspended 29 September, but any applicant put their application
up to 31st December.
31st December 2022. What thereafter?
So, when this memorandum was issued or the order was issued suspending portal?
Suspending portal, they are
First
already,
memo.
yes, putting application is not bad. That time putting application accepted, but this decision was not taken by the authority.
No, but when the first
29 September 2022.
So
Suspension.
If it is suspended on 29 September 2022 by a memo or by an order, then how you could apply?
My lord, general ground transfer, it has been now well settled. My lord, application, my lord, suspended, portal suspended, but any applicant.
Now the portal is suspended. Whether anybody can apply online?
No, not.
Because that option will
That
not
option,
be there.
that has been listed.
Portal is not operational.
Operation.
So after suspension order was claimed, how this applicant teachers were permitted to apply?
My lord, that point of time, my lord.
Yes.
My lord,
that is to be clarified by you.
My lord, that is to be clarified by the government, state government, because my lord, the portal is
clarification from you that the portal was suspended from 29th of September 2022. How petitioner could apply on 5th December 2022?
My lord, that my lord, the portal of my lord, the authority, my lord, operates the portal, my lord. They can, my lord, NIC, my lord. How, my lord, they
today teachers cannot apply.
Cannot. 1st of January 2023, it has totally debarred. Second notification.
So why? How long this will be kept suspended?
Well, that is state to reply, Malala. State authority.
So, affidavit service filed. Record.
No, near it.
Lawyer advocate for the petitioner. Yes, lawyer advocate for the petitioner submits an application for transfer on general ground using the district was made on resource portal on 5th December 2022. So, authority where petitioner is presently working forwarded the transfer application to the concerned district inspector of schools within the team on 23rd December 2022. And the district inspector of schools in his turn processed the transfer application and forwarded the same through portal to the West Bengal Central School Service Commission on 28th December 2022. Stop. Next paragraph. Grievance of the petitioner is transfer application is yet to be decided by the commission. Next paragraph. Learned advocates representing commission and board have submitted, perhaps due to suspension of portal, contemporaneous decision could not be taken on transfer application. Next paragraph. However, it is submitted on behalf of commission. If concerned authority is directed, transfer application shall be decided in accordance with law. Next paragraph. Having considered the submissions made on behalf of the parties, which petition stands disposed of, directing Secretary West Bengal Central School Service Commission to decide transfer application of the petitioner by 6 weeks from the date of communication of this order, and the decision to be communicated to the petitioner by fortnight thereafter. Next paragraph. It is made clear that suspension of portal shall not be a ground to reject transfer application. Next paragraph. Leave is granted to the learned advocate for the petitioner to amend the cost title in course of this day and add Secretary West Bengal Central School Service Commission as additional respondent. Stop. However, service of notice upon additional respondent stands dispensed with since commission is represented by learned advocate. Next paragraph. Writ petition stands disposed of by the service copy. Amend the cost title.
Yes.
Item number 20.
This is the airport of recommendation in upper primary school. My lord, I have made application within 9
Which for the commission?
but I have served.
For the state, my lord.
Lordship, I am appearing for the state. My junior is physically present. With our instruction is there, your lordship.
Within 9 days, within 9 days of recommendation.
No, it has to be decided by the commission.
Yes, your lordship.
Why so?
But within 90 days that, my lord, that prayer has been.
When you have served upon the commission, find it out.
My lord, correction, it is required another day because the vacancy position it is 9 minutes. It is available or not. You not pay, you not serving and vacancy.
Mr. Rai, accept the notice, appear in this matter, obtain instruction whether vacancy is lying or not, and come back. Because the issue has already been decided in other matters. So therefore, you appear in this matter. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. In spite of service of notice, West Bengal Central School Service Commission is not represented. Learned advocate for the petitioner is directed to serve notice upon Mr. Sunit Kumar Rai, learned advocate, who usually represents commission. The concerned authority of the commission is directed to concerned authority of the commission is directed to regularize engagement of Mr. Sunit Kumar Rai, learned advocate. So, next paragraph. Mr. The learned advocate for the commission is directed to obtain instruction whether the post against which petitioner was recommended, whether directed to obtain instruction whether the post against which petitioner was recommended in terms of recommendation memo dated.
Recommendation memo dated just 23rd November 2020.
Page
16. Page 16, 23rd.
Is West Bengal recommendation. Just কি বলছিলাম? Recommendation memo dated 23rd November 2024 is still lying vacant or not. Next paragraph. List the matter under the same heading for further consideration on. August 2025. Instruction take it back. State, take it back, your instruction. Next.
Item number 21. I am for the petitioner in this matter. This is my affidavit of service. Kindly come to page 79, general ground transfer pending at the end of the commission. Page 79. Application dated 7 September. 7 September 2023.
Your transfer application is dated 7 September
September.
2022. And it was forwarded to the commission on 23rd September 2022. Yes, let it be decided. Issue. Secretary's party.
No.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. And advocate for the petitioner submits transfer application on general ground within bracket distance was made on Utsochi portal on 7th September 2022. And the school authority where petitioner is presently working forwarded the same to the concerned district inspector of schools within bracket AC on 21st September 2022. Stop. On receipt of transfer application, district inspector of schools AC processed the same and forwarded to portal to the West Bengal Central School Service Commission on 23rd September 2020. Grievance of the petitioner is still date. Transfer application. No, grievance of the petitioner is transfer application is yet to be decided. Till date corona is yet to be decided. Next paragraph. Commission. You are for the state. State respondents and West Bengal Central School Service Commission are represented by learned advocates who have jointly submitted. Perhaps due to suspension of portal, contemporaneous decision could not be taken on transfer application. Next paragraph, however, it is submitted on behalf of commission. If concerned authority is directed, transfer application shall be decided in accordance with law. Next paragraph, having considered the respective submissions made on behalf of the parties, the petition stands disposed of, directing the Secretary, West Bengal Central School Service Commission to decide transfer application by 6 weeks from the date of communication of this order. Stop. The decision to be taken by the Secretary shall be communicated to the petitioner by fortnight thereafter. Next paragraph, it is made clear, suspension of portal shall not be a ground to reject transfer application. Next paragraph, leave is granted to the land advocate for the petitioner to amend the cost title and add Secretary, West Bengal Central School Service Commission as additional respondent in course of this day. Stop. However, service of notice upon the additional respondent stands dispensed with since commission is represented by learned advocate. Writ petition stands disposed of. Urgent Xerox service copy. Next.
Grateful to Lordship.
Item number 22.
Matter me Lord, Lord transfer of him Lord of my client Lord to the petitioner Lord on medical ground. Lord, he is suffering Lord. Lord, from Lord cardiac.
Who is suffering?
Lord, the teacher, the petitioner here Lord.
Where is your application?
Here,
Offline, not in prescribed. Offline application, but not in prescribed form.
Lord, page 74 Lord.
No, you have to file an application in prescribed form because there is a judgment by the division bench in Tumusri Kormokar.
And direct me Lord, I can. Leave granted.
The second time. আনলাম বলে শেষ হয়ে গেল এগুলো আলাদা ওগুলো আমার আবার আনলাম থেকে সেকেন্ড
এই একটা জাজমেন্ট একটা কপি তুলে রাখো তো আমার দাও একটা কপি লাগে মানে এই পার্টিকুলারটা নিয়ে আমায় দিয়ে দাও জাজমেন্টটা আমি থাকতে পারি বার করবো ডিস্টেন্স গ্রাউন্ড মেডিকেল গ্রাউন্ড অ্যাপ্লিকেশন সেলফ মেডিকেল গ্রাউন্ড টিচার আচ্ছা affidavit of service and supplementary affidavit filed affidavit of service and supplementary affidavit are filed today on behalf of the petitioner and same are taken on record. Next paragraph, petitioner made an application for transfer since petitioner is suffering from cardiac problem. Stop. However, on perusal of the writ petition, it appears transfer application made by the petitioner on 18th March 2025 is not in, and it is made to the DI. DI has no authority. It is transfer application, which is not in prescribed form and it is not addressed to the appropriate authority. Next, to the appropriate authority. Next paragraph. Next paragraph. Reliance is placed on the judgment. Reliance is placed on the order of the Honorable Division Bench dated 14th February 2025, passed on an intra-court appeal being FMA 103 of 2025 within bracket Tanushri Kormokar versus State of West Bengal and others. Stop. In Tanushri Kormokar Sutra, it has been decided that once a thing is required to be done in a particular manner, it should be done in such manner and not otherwise. Stop. The moment the form is prescribed in the rules, shaping an integral part of the statutory provisions, it cannot be whittled down, not to be done away at the behest of the beneficiary of the said rules, nor the other stakeholders of the said rules can dispense to it the strict adherence of such statutory norms. Next paragraph. Next paragraph. Admittedly, in the present case, transfer application was not made in prescribed form. Therefore, a ratio of Tanushri Kormokar Sutra comes into play. Now, therefore, in view of ratio of Tanushri Kormokar Supra, petitioner is required to apply for transfer in prescribed format. Stop. In absence of appropriate transfer application made in prescribed format, direction ought not to be passed, directing the concerned respondent authority to take steps based on such transfer applications. Next paragraph. Hence, writ petition stands dismissed. However, this order shall not preclude the petitioner to make transfer application in accordance with law. Stop. Urgent xerox. Nothing can be done because similar order I had to pass in other matters.
Get rid of this.
Next.
Item number 23.
Agree for the consideration of my representation that is appearing at 21.
Who are you?
Lord, I am the white teacher who is cited from the Lord, the representation, I have taken the two grounds for consideration by the disciplinary authority. First, Lord, he was arrested in connection with a case that was instituted in pursuance of my application. Because under section Lord, 460, 467, 468, 471, because Lord, the some of the Indian Penal Code of the Indian, because Lord, the some fabricated document was prepared, forgery, etc. and all relating to the modesty of a woman, and that is why he was taken into custody for Lord, the 28 days. First and second is that Lord, the kindly turn over Lord, the
Now the private respondent is working in a school.
My Lord, still Lord, kindly come to page 24 of my
Where is the school of
I have given page 24 of the representation, kindly come. But these are the petitions cases that has been filed by the private respondent before your lordship, before the different benches of this honorable court. And Lord, the most of the day, Lord, he remains absent in this court. And Lord, the kindly come to next year.
Page 24 are the description of writ petitions.
Writ petition filed by
the petition.
Filed by the private respondent. And Lord, the kindly come to next page 26.
Now, what you have prayed for in this?
Lord, I filed the representations. In accordance with law, proceeding should be initiated against you. In accordance with.
You made this representation before whom?
Before the all authority, Lord, the kindly come to page 21. Lord, that is the DI, that is School Education Department, that is Lord, the headmaster, managing committee, etc.
But this is not your representation. It's a representation of, it's a demand justice. Demand justice.
Lord, kindly come to page.
What is the stand of the board?
First of all, my lord, any person raising any demand of justice before court will not be court. Only if this concerned school authority or the DI send some complaint for the
Who
board
is happening for the state?
or the concerned school.
How you have served?
Lordship, if board starts working on it, then Lordship, anyone having any device, this is a matrimonial dispute, and out of that this is cropping up.
You have not served upon government bidder. That's why I know what is happening for the state.
School is also necessary party. School must also.
Perhaps has been
Yes. School is far made party and the
how school has been served so many.
ending with 986. Kindly see page 18.
Just a minute.
Yes, my lord, আমার একটু বলার আছে আমি প্রাইভেট
I'm not hearing today. First, I will hear the school authority and the state, then I will hear.
my lord, actually there is very
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. It appears office of the government pleader has not yet been served. Learned advocate for the petitioner is yet to serve notice upon the learned government pleader, enclosing copy of this order and copy of this writ petition by 7 days from date. So, next paragraph. Since Krishnapur Adarsh Vidya Mandir, Kolkata. It is under DI Kolkata.
Also, we solve on that.
Barashat DI. Krishnapur Adarsh Vidya Mandir, Kolkata না করে করো North 24 Parganas. Being respond number 6. Since headmaster of Krishnapur Adarsh Vidyalaya, North 24 Parganas, being respondent of 6 is not represented. Night advocate for the petitioner is directed to serve another notice upon the respondent of 6, including copy of this order by 7 days from date. Stop. Further affidavit of service shall be filed on the next date. This is the matter under the same heading on 9th September 2024.
my lord, affidavit of opposition আমি কি জমা দিতে পারবো?
Court has not directed you. Service tax.
Item number 24.
আগে দাঁড়াচ্ছি না
Petitioner?
Subsequent to that, Malad is successful in the licensure SLST and he got appointment in the school. Malad, thereafter he has been called for the personal test, but since he joined in the service, Malad, he has not been allowed to participate in the all personal test. He got the judgment of the school and lost job, Malad, and he has just a representation since Malad he is
In which selection process he could not participate.
take first SLST.
First SLST has been set aside.
Because first SLST right now, before that one he passed the state examination and he was passed one testing with regard to the upper primary. This is page 18. Kindly come to page 18. Given the data for personal.
What are the selection process where petitioner participates?
Two selection process. First, the first SLST 2016 upper primary, and the SLST for the ISM for the 910 with regard to 2016.
910.
910. He joined.
Now, up to which stage petitioner participated in first SLST 2016 upper primary?
Personal test he has been called for in 2021. My lord, since he has already joined the service, my lord.
Where is the দেখো কালকে অনেকগুলো order দেওয়া আছে তো? Copy আছে। Commission is not made party.
But the state. 910
order কালকে অনেকগুলো দিয়েছে, 3খানা order পাস করেছে। Judgment form. অমিত নিয়েছে। আছে? Well, not today. Bring that order. Ask Mr. Dr. Patro.
I
He
shall
will supply.
910 he was working subsequently. I lost got
Side.
He knows this.
No. Very well on Monday. And not this week.
Get.
Item number 25.
I'm for state respondent.
Okay. You are for the state?
Yes.
Assistant teacher? When superannuated? Pension payment order? 2015. Yes, disposed of. করে দেবে এটা দেখে। Next.
Item number 26.
I'm for the statement.
Do you have the copy of the order in your those matters where petitioners participated up to the stage of document verification and thereafter did not participate? Yes, yesterday also there are you had two matters. Give me a copy or give me a reference to my officer. They will obtain an order. They will take a print out. Yes. বার করে নাও। Yes. Yes, Mr. Chola. Husband of the petitioner was headmaster. Yes.
December 2027.
December 27 will retire.
2007.
Who retired on 31st December 2007.
And Malati was died on 2nd January 2013. Here was the area salary used from January 88 to 28 February 2007.
January 88 to 28 February
2007. And on 31st.
So why you are coming after such a long time?
31st October 2019, the husband of the petitioner was died.
Then what happened on 2nd January 2030?
The claim of arrears made before the authority, petitioner made an
6 years after retirement.
Yes, because he decided the issue by the DI and memo issue, I am entitled, petitioner has been entitled for the arrears rate 2,45,000.
that memo was issued by the DI on March 2030. And subsequently thereafter, my lord, the
So therefore,
paper
2,45,000 was issued in favor, was sanctioned in.
that she will not disperse it in favor.
Where is that sanctioning memo?
of the-
When died husband?
Died, my lord, 31st October 2009.
Where is the sanctioning memo?
My lord, the kindly page 90.
একটা কপি দিতে বলছি
Well,
সৌমিদার কাছে নিয়ে আসবো ওখানে লাগবে
It's the office order, my lord, issued by the district inspector of school.
We'll come back at 2. Not today. Not today. For the list.
Item number 27.
I'm appearing for the state, my lord.
Who is for the petitioner?
I am for the petition.
You are for
I'm
the
for the
state.
state, my lord.
My lord, retired from service, my lord, on 31st October 2004.
31st?
October 2004. Since more retired
2004.
Yes, since retired dues are not paid, my lord, petitioner filed it. Before this on the High Court, on the Supreme Court order 7. Despite order passed by the Honorable Court, since no steps taken, my lord, petitioner filed contempt application. And in the contempt application, they filed compliance report. My lord, I'll come to page number 10. They have paid the other due, all other due.
What you are paying for in this petition?
Petition for interest.
Interest, my lord, kindly come to page 39.
Disbursed interest. May I read? Disbursed interest for
Just a minute. Wait.
Yes.
Yes. This order was passed by the coordinate bench on 2nd May 2013.
Then, my lord, in contempt
Then
application.
contempt application, what is the order?
The compliance report has page 39. And ordering portion, my lord, page 3, last paragraph. Page
Page
3,
39.
Yes.
Where is the order in the contempt?
Contempt draft. After filing of this compliance report, my lord, contempt has been dropped.
What do you mean?
I am coming, my lord. Kindly come to page 40, paragraph 3. May I read, my lord?
Page 40 is paragraph 5.
3.
Page 40. Previous writ petition, it was page 40. In the present writ petitions, it is page 40. Previous writ petition, page 40 is present in present writ petition, it is page 39.
It starts from 39. Yes.
Yes, page 39, paragraph 3.
Paragraph 3. But at the very outset.
Just a minute.
Interest for area pension and gratuity for the period from 1st November 2001 to 8 November 2013 has been paid by such only on 27/11/2024. There is, my lord, I am entitled to get interest of the amount of 3,31,269 from the date of 8th November 2013 till the actual date.
My lord, he is paying, my lord, on interest one portion, and my lord, the dues amount, upon the dues amount. Kindly come to page 39 as my lord.
Now, court directed the responsibility to release terminal benefits to the petitioners within, including area together with interest from the date in between the period for the period between due date of payment and actual date of payment. Due date of payment and actual date of payment.
Actual date
Now, when the payment was made.
payment
Due date is rightly determined, 1st November 2001.
Payment made, my lord, on 27th November 2024, but it was supposed to pay on 8th November 2013, my lord.
Disbursed interest for the arrear pension and gratuity for the
period from 1st November.
arrear pension was paid on 8th November 2013.
Yes.
That's why up to 8th November 2013 it was calculated.
My lord.
Calculated from
Has tried to appreciate the position. Also disbursed interest for the arrear pension and gratuity for the period. Just a minute. For the period from 1st November, you retired on 31st October 2001.
Yes.
So from 1st November 2001 to 8th November 2013 has been paid with a bill dated so and so date 27 November 2024.
But I was
along with interest.
I was entitled to get the interest on 8th November 2013.
Up to 8th November 2013, it was paid.
But this amount, it was kept pending before the authority concerned.
No. When this area dues were paid to you.
2024, 27th November 2024.
Area was paid in 2024.
No, interest.
My lord, arrear along with interest has been paid on to the November 2024, 27th November 2024, my lord. My lord, his total dues amount is 78,033 rupees plus 85,608 rupees. That is total 163,641. Along with interest part, my lord, 1,67,628 has been paid on 2024. My lord.
Tell me when this gratuity and arrear pension was paid to you.
Check number such and such dated 29 October 2013.
So according to you, it is to be calculated based on 29th October 2013.
No. Interest part. I am only interest part.
For which these are the relevant dates.
Interest for the pension and gratuity.
I am asking you when gratuity and arrear pension was paid, were paid to you.
Relationship is on 29th October 2013.
Arrear pension 29th and gratuity 29th October, both dated 29th October 2013. Now, pension disbursement, disbursed interest for arrear pension and gratuity for the period 1st of November 2001 to 8 November 2013. So this is the period for which you are entitled to get interest in terms of the order passed by the coordinate bench. Because come to page 37.
But that
Please come to page 37. The respondent number 3 is directed to release the terminal benefits. The petitioner within May 31, 2013, including arrears together with an interest at the rate of 9% per annum on the arrear amount for the period between the due date of payment and actual date of payment. If actual date of payment is 29th of October 2013, then you are entitled to get interest up to 29th October 2013. Authorities calculated till 8 November 2013. What is the wrong in it?
The interest was calculated from 1st November 2001 to 8 November 2013. So it was supposed to pay, my lord, on 8 November 2013. But they have paid in 2014. Interest cost.
But interest, payment of interest, right to receive interest was crystallized with the order dated order of the coordinate bench. That was allowed till the date of payment of arrear and gratuity.
I only pay, my lord, that interest was paid on delay.
Like interest on interest, my lord, he is giving.
Yes, because you paid it in 2024.
Yes, my lord.
Why after such a long time? Because what was the order passed by the court? Please come to
My
page
lord,
37.
definitely it is a
Please come
negligent
to-
part of the respondent authorities, my lord.
Come to page 37.
Yes, my lord.
Read it. First paragraph, last line. The respondent number 3, that is DI.
Yes, my lord.
Respondent number 3 is DI. The respondent number 3 is directed to release terminal benefits to the petitioner.
My lord.
Within May 31, 2013, including arrear together with interest, along with 9% per annum on arrear amount for the period between the due between the due date of payment and the actual date of
payment.
So everything was required to be paid by 31st of May 2013.
2013. Yes.
When you have paid the interest?
2014, my lord.
24.
Yes, my lord.
What?
2000. Sorry, my lord.
Then
sorry, my lord. 27th November 2014, my lord. 24, my lord.
So it was required to be paid by 31st of May 2013.
Yes, my lord.
That was the cutoff date.
Yes, my lord. Now
you paid on 27 November 2024.
Yes, my lord. Yes, my lord. That is the negligent part. Yes, my lord.
Entitled to get interest because it was payable to the petitioner
in the year 2000.
May 2013.
Yes, my lord.
You released the check towards arrear pension and gratuity on 29th of October 2013. That is beyond 2013.
Yes, my lord.
Now thereafter, ultimately interest was paid on 27 November 2024.
Yes, my lord. Now, yes, my lord. This is the negligence.
11 years delay in paying interest.
Yes, my lord. This is that part, my lord. I have no objection at all. I have come. I am only point.
So therefore, since there is a delay in paying benefits, that is arrear, then gratuity, arrear pension, gratuity.
Gratuity, yes.
There's a delay.
Yes.
Delay up to what extent? From 1st of June 2013 to 29th of October
2020.
So this will carry interest.
Yes, my lord.
And regarding interest on gratuity and arrear,
yes, that is
it was payable on 31st of May 2013.
Yes, my lord.
This interest
Amount
part will carry further interest.
Yes.
From 1st of June 2013 to 27 November
2024. Yes, my lord.
What
yes,
is?
that is if that part, my lord, I have, my lord, this is the
So why your contempt was dropped?
Since
order has been complied, my lord, as per his.
Where is the order in the contempt?
Last page, my lord, page 47.
After 11 years, you paid interest, which was required
That's why he has come, my lord.
by 31st of May 2013.
47, page 47.
Page
The
marking.
compliance report filed
Page 40, page
47.
Annexer P9.
47.
Annexer P9.
Annexer P9.
Contempt dropped January 2025. 7th January.
Since the compliance report filed by the respondent authority, contempt filed.
It's okay. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner retired on superannuation on 31st October 2024, 31st October 2004. But retirement dues including pension were not paid to the petitioner within reasonable time, prompting the petitioner to file a writ petition being WPA 10795 of 2013. Stop. Said writ petition was disposed of with an order dated 2nd May 2013 by a coordinate bench, directing the respondent number 3 now directing the district inspector of schools AC Bankura being respondent number being respondent number 3 hearing to release terminal benefits to the petitioner within 31st May 2013, including arrears together with an interest at the rate of 9% per annum on arrear amount for the period from now for the 9% per annum on arrear amount, on arrear amount from the date terminal benefits were due to be paid to the petitioner till the actual date of payment. Stop. Subsequently, petitioner had to initiate a contempt proceeding being CPAN 928 of 2014, which was disposed of by a coordinate bench video order dated 7 January 2025. In view of compliance of the order, but there is a problem. There is one problem. Contempt, you have not obtained any leave. Come to page 46. Learned Counsel appearing for the applicant submits that order dated 2nd May 2013 passed by his lordship, the Honorable Justice Devashish Korbu, by his lordship has been complied with. As the order dated 2nd May 2013 has been complied with, CPAN at so and so is disposed of.
But I was not.
Where is the leave? Normally leave is granted. That it is not a correct compliance.
On that particular.
Generally, court passes an order that if petitioner is agreed with regard to the compliance or payment of interest leave is granted to take steps in accordance with law. Where is that? After this satisfaction recorded by the coordinate bench in the order dated 7 January 2025, what is the scope left open to consider the writ petition afresh?
Sanction date on 7th January 2025. Was submitted.
But the court recorded that the learned counsel appearing for the applicant submits that the order dated so and so as passed by the honorable just by the coordinate bench has been complied with. After that, what remains?
That noting is there, but my lord, regarding compliance, I was not aware.
If it is court upon recording satisfaction that order was complied with, pass this order, dropping the contempt proceeding. After that, nothing remains unless until the express leave is granted by the coordinate bench. Sorry, no. No. কি বললাম বলো তো? হ্যাঁ না, ওই কন্টেম্পটের পার্টটা বলো। Second January, 7 January 2025. In view of compliance of the order dated 2nd May 2013, passed by another coordinate bench on the writ petition being WPA 10795 of 2013. Next paragraph. Petitioner, by filing this writ petition, has made a prayer for payment of further interest due to delay caused in releasing the amount in terms of the order dated 2nd May 2013. However, on perusal of the order dated 7 January 2025 passed in contempt proceeding, it appears that coordinate bench disposed of the contempt application being CPAN 928 of 2014 on recording satisfaction. That order dated 2nd May 2013 was complied with. Stop. On perusal of the order dated 7 January 2025, it also does not appear that any leave. It also does not appear any leave was granted. Leave was granted to the learned. Leave was granted to the petitioner to raise dispute regarding payment of interest. Stop. Next paragraph. Hence, on this writ petition, no relief can be granted. Writ petition stands dismissed. Urgent लक्षात wait करो.
Item number 28.
Lord, I am for the petition. My earlier petition I have filed with a prayer for a direction after the constant response. I have paid bill. As I have obtained the prior permission from the constant authorities for pursuing my higher sir. And my lord, the same matter was considered by the contempt court by an order dated by the November 2016. By directing the concerned respondent number being the district inspector of Purbo Medipur who
the order was passed by the DI on Harback on 11th April 2017.
Yeah.
And you are coming after 8 years.
No, my lord. My lord, the difficulty is that my lord, in the order, my lord, the DI has my lord kindly have
No. Question is why you are coming after 8 years.
My lord, in the meantime, my lord, I have continued, my lord, made contact with my asked my landed.
Where is the explanation of delay?
Pardon, my lord.
Where is the explanation of delay?
Yeah, my lord, the explanation, my lord, I have given my lord a paragraph 9, my lord. And my lord, not only that, my lord, regarding my lord, I have relied on a document, my lord,
passed by where this point came up for consideration before the Honorable Supreme Court, my lord, wherein, my lord, the Honorable Supreme Court, my lord, has decided the issue that, my lord, if the circumstances is so compelling, my lord, in that case, my lord, the Honorable Court has can
The compelling circumstances. Where is the where are the compelling circumstances so far this matter is concerned?
my lord, and my lord, this is the continuing breach, continuing.
Where is the compelling circumstances?
But the point is that this is the my fundamental right has been my lord, breached my lord, only for the with a wrong decision my lord, by the DA. My lord, kindly have a look at the order my lord, the passed by this honorable court. My lord, the honorable court by an order dated my lord 15/11/2016 my lord was directed the DI to consider the application. And my lord, upon hearing my lord, the order to be communicated to me. And my lord, at the time of hearing, kindly have a look my lord at page 6. While my lord, the DI has considered that in my earlier application, my lord, my said representation was annexed the T9. But my lord, at the time of hearing, the concerned DI has passed an order on the basis of the annexed T4. And my lord, for that reason, my lord, the DI has passed this order, wherein my lord, I have been directed to modify the solemn order passed by this honorable court. This is the main difficulty, my lord. My lord, this honorable court, my lord, has directed to consider my representation dated 9/11/2000, 9th February 2016. That was appearing at Annex T9. That has also been recorded in the DI order. But my lord, at the time of hearing, the DI has considered a separate representation.
What is annexure P9 in the previous petition? What was annexure P9 in the previous?
Page 32.
That I have annexed, my lord, that's appearing at page 32.
Please wait. Please wait. Issue. Affidavit of service filed on behalf of the petitioner is taken on record. The writ petition, order of the District Inspector of Schools, AC. April 2017 is questioned. It appears that writ petition has been filed after 8 years. It appears that writ petition has been filed 8 years after impugned order was passed by the concerned district inspector of schools AC Purvamedinipur on 11th April 2017. Stop. Writ petition was instituted on 19 July 2025. Next. There is no scope for passing any interim order. Stop. Next paragraph. Let the issue be decided on exchange of affidavits. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Affidavit in reply thereto, if any, be filed by 1 week after ensuing annual vacation. Stop. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Next paragraph. To communicate this order on affidavit respondents by 7 days from date and file further affidavit of service on the next day.
Lord, I am really very confused because the court directed annexure P9, but it was decided P4. P9 is, my lord, the 9th February 2016. Now, my lord, on the alternatively, your lordship can set aside this order and remit it back to, my lord, to the DI to take a first decision, because he has, my lord, taken into consideration P4. It's, my lord,
This is the only difficulty.
this is the problem. Though, my lord, there is a delay. There is a delay, abnormal delay. Page 36, my lord, the last paragraph 6. দাঁড়ান না জোসেফ, পড়তে দিন এটা, আমি তো বলে দিলাম যে
Court directed to consider annexure P9.
But it has
But
been,
the
my lord,
DI
recorded
considered
P4.
annexure P4.
P4. That is why he said,
Relating to
DI said,
issuance
my
of-
lord, modification of this order.
P4 is relating to issuance of prior permission.
Therefore, my lord, this order, my lord, if it's subject to, my lord, the question of delay, this order, my lord, should go, and, my lord, this matter be relegated to the DI to take a decision. If this representation is, my lord, within the file of the DI. Because there is, I do not have any, there is no seal at all. And by this time, the petitioner retired in December 2024.
P9 is page 32. P9 is page 32. That is prayer for grant of higher scale of pay.
Yes, yes, I said so, my lord.
P4 was considered, that is relating to issuance of prior
Prior
permission.
Therefore, my lord, it can be disposed of,
It is
setting
out.
the seat.
Affidavit
And
is
only
filed.
thing, my lord, if your lordship so right, my lord, there is no seal of receipt of DI of school, if it is on the record of the DI of schools.
No, in that event, I will grant them leave to file a fresh
Yes,
representation.
yes, that would be better. And by this time, he has retired.
Retired already?
Retired, December 24, 2024. He has retired.
December 2024. And thereafter, the petition is filed. That's why 8 years delay. Affidavit service filed on behalf of the petitioner is taken on record. Stops. In the writ petition, order of the District Inspector of Schools AC Purvamedinipur, being respondent number 3 is questioned, whereby respondent number 3 refused to take decision take decision in terms of the order of the coordinate bench dated 15th November 2016, passed on the writ petition being WPA 14405 of 2016. Stop. The coordinate bench directed the respondent number 3 to decide representation of the petitioner seeking sanction of higher scale of pay, which was annexure P9 to that writ petition. Stop. In the present writ petition, said document is said representation dated 9th February 2016 at page 32 of the writ petition. So, on perusal of the representation dated 9th February 2016, it appears that petitioner prayed for sanction of postgraduate scale of pay, but inadvertently respondent number 3 proceeded to decide annexure P4 to the writ petition being WPA 14405 of 2016 instead of annexure P9. Stop. It further appears that no modification of the order dated 15 November 2016 passed by the coordinate bench on WPA 14405 of 2016 is needed. Next paragraph. However, Mr. Acharya, learned advocate representing the state respondent, submits that representation which is required to be considered in terms of the previous order, in terms of the order dated 15 November 2016 passed by the coordinate bench, is dated 9th February 2016, which may not be on record of the respondent number 3. So, next paragraph. Therefore, leave is granted to the petitioner to make a representation to the respondent number 3 by fortnight from date, claiming postgraduate scale of pay. Stop. If such representation is made within the aforesaid time, respondent number 3 is directed to decide the same in accordance with law by 8 weeks thereafter. By 8 weeks thereafter, on granting opportunity of hearing to the petitioner or his representative. Stop. Respondent number 3 shall pass a reasoned order and same shall be communicated to the petitioner by 10 days thereafter. Stop. Next paragraph. Order. The memo dated 11 April 2017 passed by respondent number 3 stands set aside. Dispose of police. The writ petition stands disposed of urgent xerox.
My lord, I missed, my lord, your lordship recorded that he has already retired.
not required, it's not relevant. Court, DI will consider it.
Very. Yes. Deeply obliged.
Because his entitlement accrued in
Yes, on that
much
point,
earlier.
yes.
And he was sanctioned honors graduate scale of
Yes.
that I've seen.
Item number 29.
This is the transfer application. The second round of litigation. Page 80 is your options order. It has been offline transfer application not specified before. Lordship granted me to file a fresh application as per this matter. The petitioner filed an offline transfer application. Part on meeting with the medical term. What is the medical term? After that is just copyright.
Which is not an. Then where is the scope?
That is why I am already filed this. But I transfer that might. Why already filed, but all committed by the petitioner. It should be on distance order. Petitioner is eligible for distance.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Learned advocate for the petitioner prays for leave to withdraw a writ petition with liberty to file. Prays for leave to withdraw a writ petition. Since transfer application was made by the petitioner, on medical ground, but the disease which was disclosed in the transfer application is not notified disease, which would enable the petitioner to take transfer. Next slide. Respondents are represented by learned advocates. Next slide. In view of aforesaid submission, writ petition stands dismissed as withdrawn. However, this order shall not preclude the petitioner to apply afresh for transfer in accordance with parties to act on the server parties to act on the act on server copies.
Item number 30.
One of the petitioner before your notice, rather of the employee has filed a petition.
Where is the legal year certificate?
But legal year certificate, that I do not have, but kindly another second order. There, my lord, after column 10, my lord, the name of the petitioner is mentioned. And I also on paragraph 17 of my petition, I have stated that I am the only leader.
Instant payment order is not readable.
I'm sorry, my lord, I have to
File a supplementary affidavit.
My lord, this is my instructions as per your lordship. Instructions.
What is I have not called for any. You tell me on reading the same. What is your instruction?
My lord, the instruction is that Kamala Pradhan filed a writ petition for her entitlement of pension from the date of retirement. The said writ petition being WPA 21427 of 2023 has been disposed of by the Honorable Court on 9 February 2024 with a direction to verify the records to ascertain whether Srimati Pradhan exercised the option and refunded the employer's share in due time, and if the documents affirm, allow the petitioner error pension from the date of retirement. Then, my lord, the petitioner has no right to claim the error pension in terms of DCRB scheme 1981 pension in favor of late Kamala Pradhan has not been sanctioned from the date of her retirement in compliance with
that
this.
is decided in Abdul Ghani. Why you are reading it? The usual order is being passed regularly. Issue is no more res integra. Therefore, this is for your consumption. You read it and place it if it is relevant. Otherwise, do not place it. Yes, where is the pension? File a supplementary affidavit. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner relies upon a pension payment order. However, the copy of the state pension payment order, which is enclosed to this writ, which is appended to this writ petition, is not legible. Stop. Next paragraph, leave is granted to the petitioner to amend the, leave is granted to the petitioner to file supplementary affidavit in order to bring on record legible copy of pension payment order. Stop. Let such supplementary affidavit be filed by 10 days from date with a copy upon the learned advocate representing the state respondents. List the matter under the same heading on 10th September 2025.
I'm great.
I'm grateful, my lord.
Next.
Sorry, sir.
And
The Madrasa matter.
Yes,
I
Madrasa
do not
not
have
in
determination.
just appointed by the Madrasa.
Learned advocate representing the parties submits. Or learned advocates representing the parties submit. Case study on the issue involved in this writ petition relates to Madrasa education. Representation will be considered. Next one. Writ petition stands released due to want of determination and be placed before the bench having determination. Next paragraph. Leave is granted to the learned advocate for the petitioner to amend the presentation form. Take back your affidavit of service. Item number 32.
The matter relates to grant of area pension due to conversion of option from CPF to GPF.
Area pension.
Area pension from the date of retirement.
Assistant teacher.
Assistant teacher.
When superannuated?
On 30th April 1995.
Pension payment order?
My lord, 5th October 2015.
Which post do একটা কালেকশন আছে দেখে নিন। Next.
Item number 33.
মাদ্রাসা।
Transfer matter, my lord. The second round of litigation, my lord. Lordship pass, my lord, kindly see, my lord, page number 37. 11 portion, my lord, 38. Earlier writ application disposed of for director, my lord, commission to consider. Thereafter consider, my lord. Rejected, my lord.
37.
Yes, my lord. 37, 11 portion, my lord, 38. Between stand because of directing the chairman with irrespective 3 to dismiss.
Yes.
Thereafter, kindly see my page number 41. Pass. Page 41.
So you are challenging page 41?
Not for challenging. I made a fresh application as per direction of the page 41. Page 41 can see. The commission cannot issue recommendation of transfer in favor of the or the
Just a minute, wait.
Submit fresh choice. ফেস চয়েস দিতে বলেছিল সেখানেও নতুন চয়েসটা কোথায় ফেস চয়েস হচ্ছে কোনো এই
স্কুলের নাম কোথায়?
So there are no vacancies in those schools preferred by you.
Separate offline application, next page, page 43.
Offline applications.
difficulty, my lord, and page 41 তুমি বলো না SSC directed to you may submit fresh choice under section 4D of the prevailing year. So
but the same problem, chairman was directed to take decision while secretary has taken decision.
But
what your secretary is doing, he is making mess of it.
no, my lord, there was no permanent secretary, my lord. Now
why secretary has taken decision when court has
he has communicated. He has
show me that the decision is taken by the chairman.
Yes, yes, I've seen the language.
Now he'll start issuing contempt against him.
No, my lord, kindly.
This is not the first time. This is at least I have before that I have seen 3 or 4 matters where your secretary is doing this.
This order is of 3rd March. My lord, kindly see, my lord, with reference to the above, I am directed to inform you that as per Usosi portal, I am directed to inform.
Show me any decision is taken by the chairman by filing an affidavit.
That if your lordship, my lord, so directs, then I have to.
If this is your stand that the secretary has not taken decision, he has acted as post office. In that event, show me that the decision.
My lord, I don't have any instruction in this matter, my lord. I am not taking any stand and not taking. My lord, from the language it appears, that's why, my lord, I was pointing it out.
Why your secretary is doing this?
My lord, he has
unnecessarily inviting trouble.
I will inform, my lord. I will inform.
Sure.
My lord, here what happened? He was directed to file afresh. My lord, the
file your affidavit service.
Face choice. He has
cannot survive. File your affidavit service. Affidavit service filed on behalf of the petitioner is taken on record. Stop. On perusal of the writ petition, it appears Secretary West Bengal Central School Service Commission has passed order by issuing memo dated 3rd March 2025 relating to 3rd March 2025 on transfer application of the petition. However, such decision is taken in terms of the order dated 14th February 2025 passed by this court on a writ petition being WPA 2461 of 2025. preferred by the petitioner. Stop. So, stop. Next paragraph. By order dated 14 February 2025, Chairman West Bengal Central School Service Commission being respondent number 3 was directed to decide transfer application of the petitioner in accordance with law. Stop. Therefore, Secretary of West Bengal Central School Service Commission is not authorized to take decision on transfer application of the petitioner. Stop. However, Secretary has done this, which is contrary to the order passed by this court on 14th February 2025. Stop. Next paragraph. The order dated 3rd March 2025 stands set aside. Next paragraph. Chairman West Bengal Central School Service Commission being respondent number 3 is directed to decide the transfer application of the petitioner in terms of the order dated 14th February 2025 by fortnight from date and communicate the same by 7 days thereafter. Very good. Stop. It is found that repeatedly Secretary of the Commission is passing orders, though in terms of the relevant order passed by this court, Chairman of the Commission was directed to take decision. Stop. Such steps taken by the Secretary of the West Bengal Central School Service Commission is deprecated. Stop. If writ petition stands disposed of, then directed very good. I know what is happening. It's not a new issue. ওই জন্য রিপিট করলাম। দেখো এই দাও Tell your secretary that in an appropriate case,
I will tell the chairman. In this case, matter is disposed. In this, it has perhaps the chairman has taken the decision. He has only communicated. From the language, it appears. From the
authority your secretary is God.
He has been directed to inform that. That's why.
Even such direction is bad.
Your lordship directed the chairman to communicate.
Chairman cannot delegate his power in view of the order passed by this court.
Yes, yes. I will inform her. I will definitely inform. Just now.
Item number 180.
এইটার না একটা ভালো ইয়ে দাও তো, এটা একদম ছিঁড়ে গেছে পরে আমার একটা কপি ওপরে রিটেন নোটস এন্ড আদার্স বলে এটা দাও তাহলে ভালো করে কভার সারা কভার দাও তোমার হাতে লেখা ওই হাতে লেখা আমার Yes, Mr. Sen.
May I know, my lord, that this matter already heard by your lordship, my lord, days together, my lord, several days.
Yes.
My lord, I'm very sorry, my lord, I just want to brief this matter, but I have prepared myself in the meantime. Because, my lord, so far, my lord, I have understood that the issue is very limited. Very limited. My lord, the very short point, my lord, is involved in this matter. My lord, may I just indicate that, my lord, what would be, my lord, my submission, though there is, I am.
You are still additional government pleader?
No. The age.
Senior advocate.
Additional.
Additional
age.
Oh, now it has, you are promoted.
My.
Yes.
Now, my lord, the whole question is that, my lord, that the employees of now the KMDA, they are after retirement, after having been enjoyed their commuted value of pension, then whether after a certain period, according to them 15 years, 17 years, whatever it may be, after a certain period, then whether their full pension will be restored or not. Because, my lord, according to them, that whatever amount they have been paid or they received under that expression, that commuted value of pension, after deduction of the same for long, more than 15 years, now that amount already, according to them, my lord, they have, my lord, made their case in this way that the whatever amount they received under that, my lord, that the commuted value of pension, it has already been adjusted. It has already been adjusted. So after having been adjusted the said amount, so why not the full pension shall be restored now? This is their whole contention.
No, they are claiming full pension to be restoration of commuted portion of pension after expiry of 15 years.
After expiry of 15 years, because according
Not
to
from
them,
now.
no,
After
I am not
expiry of
telling.
15 years with interest.
Yes, because of the, my lord, they are resorting to the provisions contained in, my lord, the West Bengal government's, my lord, death cum retirement benefit rules, read with that commuted, my lord, the pension rules of the state government by way of notification issued for the state government employees. The genesis of their claim or foundation is based on them that there should not be any, I think that distinction between the employees of that KMDA and the state government employees. Because whatever is there, that shall be also applicable to them.
That is not the submission made on behalf of the petitioner, that there should not be any distinction in between the employees of the state government and KMDA. Rather, submission rests, so far this issue is concerned, this part of the issue
On a
is concerned,
particular clause of
on rule 52, regulation 52.
Yes.
Of
Yes.
1988 regulation.
Yes. Where
if you come to this regulation,
what we can normally, my lord, say that
it is annexed.
Yes, annexed at page 95.
It is annexed to this petition.
At page 95.
Now, straightway come to, they are not claiming any parity with the state authorities, but their submission rests on regulation 52(2). Come
Yes.
page 85.
Yes. 95. Oh, achha.
Come to page 85.
Achha.
It says that 52 regulation 52(2), any matter not covered by these regulations shall be decided mutatis mutandis on the basis of the provisions in this behalf in the rules of the state government.
Yes.
Now you will make submission. Now, what was the submission made by on behalf of the petitioners is this. Please come to page 30, regulation 38 of that
Yes.
pension regulations
yes,
of
yes.
1988.
Yes.
This
It
year
is 92.
regulation
82. Type copy. 82. Mile.
Regulation page 79.
Yes.
Mr. Sen.
Mile.
Regulation 38 says commutation of employee. An employee who is eligible for pension under these regulations shall be entitled to commute for a lump sum payment at the rate indicated in Annexure 2. Any portion not exceeding 1/3 of the pension which has been or may be granted to him under this regulation, then proviso is not relevant.
Proviso is not relevant.
Not relevant. So in one hand, regulation 38 postulates that up to the extent of 1/3 of the pension payable to the employee on the date of retirement, commutation can be made, and it will be in terms of Annexure 2. To the appended to this.
That is with regard to the, my lord, the calculation.
88.
And I have, my lord,
now in this regulation 38, there is no express provision relating to
restoration of full pension,
commutation of pension, restoration of commuted part of pension.
Yes.
Yes. Restoration of
commuted part of pension. Yes.
Now, by taking advantage of this, whether
52(2)
can be compelled to get payment beyond period of 15 years with reduced payment, with reduced pension.
My lord, my lord. Now, my lord, the first thing is this: if your lordship kindly come to again,
yes.
My lord, that
85.
That rule, yes, 85. 52(2), because 52(1) is something else with regard to the policy matter regarding amendment and something else. But 52(2), if we read it independently, then, my lord, it is very clear that the expression is any matter not covered by this regulation shall be decided mutatis mutandis, that is, my lord, the change whatever necessary or to what extent, that is the situation basis. Mutatis mutandis, case to case situation basis. On the basis of the provisions in this behalf in the rules of the state government. But, my lord, first thing, the hurdle they have to cross, I think, my lord, my submission is that this first expression, any matter, the word used here, any matter not covered by this regulation. My lord, matter means, I think, my lord, the subject. Any subject matter. Very wide commutation, lordship, subject matter. Now, subject matter here for the time being, for the proper this matter is concerned, issue is concerned with regarding that commutation of pension.
To be more specific,
I'm coming.
I hear you. To be more specific, restoration of commutation of pension.
I am coming. My lord, may I tell one thing? Yes. My lord, in several, my lord, I think, my lord, the statute and, my lord, even in, my lord, the arbitration clause, anything, my lord, what we have seen, or we regularly, my lord, accustomed to, my lord, to interact. My lord, two words are there, lord, so kindly consider one thing. Normally, my lord, we have seen that matter and then, my lord, dispute. Or, my lord, any confusion. Sometimes we have seen any confusion is there, then we can take resort to some other. Because this is not the adoption of other statute. Let's kindly consider. This is not exactly the adoption of other statute.
Just a minute. Yes. This is not adoption of.
This is not adoption of any specific provision or specific statute. It's a, in general, we say it is a residuary clause. Normally, we say it's a residuary clause. Now, to bail out from any such situation, if the case may be, then resort to. But the main thing is this, that
according to your
your
reading,
my lord.
So 52(2) does not cover this issue of restoration of commutation of pension.
My lord, because of
it has not been provided in regulation 38.
I'm coming to the my lord. My lordship, kindly, my lord.
Yes.
I know. My lord, first of all, we have to, my lord, we have to consider that whether this particular expression matter, any matter, that means any subject, whether that can be, my lord, it appears in a particular clause in this regulation, or it is covered by this regulation without taking resort to this provision. Any matter not covered by this regulation, well, my humble submission, may I tell, that this particular matter of, my lord, the commutation, my lord, it is there, 37 or 38. If we come 38, commutation by employee. This is the matter, my humble submission. Matter is this commutation, the right, what you may have to enjoy, up to you. You may opt or you may not opt it, but this particular liberty is there with regard to you may pray, you may not. But this commutation by employee is the matter. Now, today, after that first round litigation by writ petition, then my lord, matter went to the Principal Secretary Finance Department, then rejection, then this writ petition. All in this writ petition, the subject matter is with regard to not matter. Subject matter, my understanding, subject to correction is a dispute. And my lord knows that dispute in all matter, arbitration or my lord suit or my lord any proceeding, dispute is with regard to that I claim something and somebody on the other side of the table denies the same. And the dispute cropped up. Here my lord, that restoration of the commuted value or restoration of full pension after a certain period, it is nothing but a dispute cropped up. A dispute cropped up, not the exact the matter which is there, the expression matter in my lord, that section 52(2). Now, dispute may be cropped up arising out of any matter. Yes. So, first thing, my lord, my humble submission is this.
So your contention is this, that since commutation issue relating to commutation having wider connotation is provided under regulation 38.
Yes.
So therefore, the issue which is being raised on behalf of the petitioners, that it is a case where
to expand
two shall apply,
yes,
is not the correct.
It is not the correct. By my humble submission is that by way of resorting to section or rule 52 sub rule 2, the original intents and object of that particular provision of rule 38 cannot be expanded, because there is no question of any confusion, no question of any interpretation. This rule 38, it does not, my lord, invite any confrontation, any dispute with regard to the implementation of this 38. Had there been any confusion or interpretation required with regard to implementation of 38, as it is, 38 as it is,
but
there is no.
If we go in other way, following other, this regulation is the DCRB regulation, so it should be interpreted liberally.
My lord, regulation, my lord, there are, my lord, I shall come to one or.
Otherwise, consider the hardship
no.
which the employees would face.
My lord, may I tell, lordship.
And there is other thing also troubling this court. Have you come across that in any situation in any organization, that after commutation of pension, employees are not permitted to get the restoration of commutation?
I am told, my lord, a list is there. If you also allow me, that list But, in fact, my lord, this was my inquiry also. And my lord, I am told that this, at least for the time being, these 6, my lord, institutions or entity, here, my lord, the same provision. These are all autonomous, comprehensive area development authority under PNRD department, Panchayat and Rural Department. Then Netaji Institute of Asian Studies under Higher Education Department, Institute of Historical Studies, there is also Higher Education Department, SBSTC, Transport Department, West Bengal Khadi and Village Industries Board, and then Board of Waqf. At least for the time being, my lord, I can place the, my lord, particulars of the 6 institute, where, my lord, the same provision as it appears, my lord, today, my lord, so far this KMDA is concerned.
Yes.
Now, my lord, the question of hardship, yes, my lord, I can understood. Had it not been the case that it is, my lord, at their will, they accepted something. At the same time, my lord, they have relinquished, knowing fully well, some right which, my lord, might have, my lord, occurred, had it not been accepted. Lordship, kindly consider. So, and hardship, Lordship, kindly consider, balance, considering both sides.
Just a minute. Yes, yes. Yes, that is.
So first thing is that, my first answer to that, first thing is that there is no scope to resort to that 52.2 because of the fact where it appears on the face of it that matters which are not there, but here the matter is here against, my lord, Rule 38, and the caption is commutation by employee, so that particular matter is there. Now the question is that almost, my lord, the expansion of that particular clause of 38 with regard to the, my lord, the benefits percolated therefrom. Now my humble submission is this, that this
So
cannot
therefore,
be done.
Rule 52 should not come into place.
Should not come into place.
In view of specific provision.
In view of specific
under
provision, Rule 38, Regulation 38, number 1. And my humble submission is this also, that had it been a case that in course of implementation of this 38, some confusion or interpretation or something is required to take help from other statutory provision, then it may have come. But for that, my lord, the particular issue is not, my lord, regarding interpretation. This is not regarding implementation of 38. 38 implemented, they have benefited. Now the second question, Lordship, kindly consider one thing.
Since we are considering applicability of
52
38 vis-a-vis 52.2, that's why there is another issue, Mr. Sen.
My
Again, come to Rule 38.
Yes.
An employee who is eligible for pension under these regulations shall be entitled to commute for a lump sum payment at the rate indicated in Annexure 2, any portion not exceeding 1/3.
That is
So
the
it
rule.
should not be beyond that 1/3.
No.
But now it has been extended from 1/3 to 40%. In parity with the state government employees. How this has been done?
Now, my lord,
without any amendment?
No, may I tell Lordship? Even if it there, Lordship, kindly.
If I go by your submission,
yes,
that there is necessity of strict implementation of Rule 38, and it has no nexus with regulation 52(2). In that event, how employees are permitted to commute to the extent of 40% beyond 1/3.
May I?
Because there is a provision
Yes.
in the state government, perhaps
One.
Rule 83, Mr. Mojumdar, it is in the exception used on by the petitioners. Just a minute. Yes, exception, you will find it, this provision. No, that is exception is regulation 30, that is with regard to restoration. But there is a provision that 40%. That is in the writ petition.
145 of the.
140. 150. Start from 130.
Page 140 of the writ petition. Just a minute. Yes, come to page 140 of the writ petition.
Type copy 141 policy.
141 typed copy, right?
Yes. 27th October 1998, they have referred to also in the, yes, this memorandum
Where this
for West Bengal government employees.
Clause 5, maximum amount of gratuity, no, just a minute. Clause 9, page 142, the maximum amount of pension that can be commuted as per Rule 5(2) of the West Bengal Service Commutation of Pension Rules 1983 shall be raised to 40% of the amount of pension. Other provisions in the said rules will, however, continue.
Yes, it is there.
So, when
in respect of state government employees,
with introduction of this enhancement of commutation of pension from 1/3 to 40%, keeping in parity with the state government employees, beyond the provision of Rule Regulation 38, these employees are permitted to commute to the extent of 40%. How this has happened?
May I tell?
That has to be concluded. How this has happened. Therefore, it appears that in absence of any provisions relating to commutation to the extent of 40% in Regulation 38, it must have been in consonance with Regulation 52(2).
But that notification is not here, whereby that extension or
Which notification?
that up to 40% by the KMDA.
Yes, that notification is 141. So far KMDA is concerned.
141 is
yes,
regard
please
to my
go to page 141.
141 is, my lord, in respect of the 1998 circular or GO with regard to the state government employees.
No, I am just
yes.
The parent.
Yes.
Just a minute.
এখানে 40% কোথায় এটা বলা আছে? হবে তো একদিন পাওয়া যায় বাবা। 40% কোথায় করলাম?
Yes, this is in terms of 27th October 1998 memorandum, which is at page 141.
150. Malad, just a minute, Sir.
There is no parameteria provision you will find in the regulations subsequently by way of amendment.
Yes. Malad, kindly come to.
At least Mr. Talukdar could not satisfy this court on this issue. Because there is no provision how it can be answer can be given. Straightway, in parity with the state government employees, this was extended up to the up to 40%.
I'm interrupting. Page 145. I have shown to your worship. Second paragraph.
Malad, may I?
There with the
I think Malad answer is
approval
there.
of the state government, which we required to under 139 of the Town and Country Planning Act, that we have taken.
Malad, this
the
notification.
Page 145.
Page
second
145.
paragraph.
Page
Starts with-
145. Malad, this page 145, Lordship, kindly come
This
to
is
my lord.
in exercise of.
Page 145. Have Lordship got it, my lord?
That was my answer.
But this is the, my lord, that regarding, my lord, introduction of the, my lord, the revision of pension, including the, my lord, the commutation also revision. Now, this is an independent
Please,
notification.
page 145. Please.
Page 145.
Yes, yes.
Second paragraph.
Page 145.
Lordship,
The
kindly-
order dated 5th February 2010.
Page 145 is the, yes, 5th February 2010 notification of KMDA. Now, my lord, kindly, my lord,
Yes.
read with this, my lord, the order, this page 145, regarding introduction of that 40% excess.
Yes.
May I answer the query?
আমাকে বলতে দিন না একটু, এটা আমি বলে দিয়েছি।
Second,
Yes, yes.
second paragraph. Therefore,
Second paragraph.
second paragraph.
Therefore,
Under the provisions of regulation 52(1) of the KMWSA, employees DCRB regulation, the regulations are same, KMDA and KMWSA, with the previous approval of the state government.
Yes.
As communicated by the UD department by BDA, memo number so and so, and pending adoption by the authority is hereby ordered, and then this follow, and the particular portion at page 50. So
pension, family pension shall be revised.
Yes.
In
There are
yes,
the-
where is the
including
provision related
commutation.
to commutation from
That is
1/3
page-
to 40%?
At page 50 of that.
Page 50.
50, 150.
Just a minute. Yes.
Plus 6, commutation of pension.
So where is the approval of the state government?
That has been.
Pending approval. Where is the approval of the state government?
No,
We have
here,
done this.
here with the.
Let us come back to 52(1) once. Let us come back to 52(1) regulation.
This is what.
Just a minute. Amendment of regulations 52 regulation 1. Subject to approval of Calcutta Metropolitan Development Authority, these regulations may be amended or modified mutatis mutandis on the model of the corresponding rules of the state government. So where is the approval needed so far state is concerned?
Here, this refers to a memo issued by the.
Likewise, in this matter, regarding restoration of commutation, you prayed for nod of the state government for amendment of the rule.
Regulation.
Now, in case of commutation of pension to the extent of 40%, where is the approval of the state?
This refers to that.
Subject to the approval. So therefore, the Calcutta Metropolitan Development Authority can do this.
No, here the KMWSA, when the KMWSA, it is the memo issued by the KMWSA.
So if you can do this in the case of extending the limit from 1/3 to 40%, permitting the employees to commute to that extent, to the higher extent, that is in consonance with the system prevalent in case of state government employees. Without any amendment to the rule or without any approval from the state government.
No,
based on 52(1), then why these subsequent steps were taken seeking approval or amendment of regulation of 1988.
Here, this
In a similar fashion, this could have been done.
My lord, this paragraph refers with the previous approval. With
Where?
the previous, the second line. With the previous approval.
Therefore, under the provisions.
This part I have emphasized on this. As communicated by the. So it was not done of their own.
And what does it mean? Pending adoption by the authority?
This is another part. Another part, pending adoption, this part, hereby order.
What was to be adopted?
Pending adoption by the authority.
Yes, what was to be adopted?
That's the second part, my lord, but the first part here, this and particular enhancement portion at page 50, lordship will find.
So this can only be done by way of modification subject to approval of the Calcutta Metropolitan Development Authority. These regulations may be amended or modified mutatis mutandis. So where is the modification made? To regulation 38. In order to permit the employees to get the benefit of commutation up to the extent of 40%.
Here regulation was not amended.
Then?
Here with the approval of the government, state government.
So therefore, whatever may be the regulation, steps can be taken by the authority.
Order refers to 52(1).
That's why this clause or this condition has been incorporated pending adoption by the authority. What was to be adopted? Adoption of new regulations in 1988 pension regulations. So where is the amendment made to that extent?
That we have sought for that in the petition series of documents that was negated by the government. But
there was no adoption, there was no amendment.
Yes.
But employees are permitted to commute to the extent of 40%. That is in sync with the employees of the state government.
That government permitted two elements. That I wanted to say that the suo motu, the KMDA said.
So why in case of restoration of provision, restoration of commutation of commuted portion of pension, a proposal was sent for amendment of rule? This could have been done in the same fashion.
And that particular provision.
Take your seat. Yes, Mr. Sen.
Now, my lord, my answer to that, my lord, that since on the basis of.
Now we have to go by the regulation 38.
Regulation 38.
Now it's a pertinent question has been raised on behalf of the petitioner.
If the regulation 38
is
already silent, but the quantum of the commutation
has been
enhanced, then that means that the government employees rules, whatever for them that has been followed, then the rest of the other full rules that is regarding restoration of full pension, that should be followed. It is their case. My humble submission is that each and every steps are to be taken, my lord, considered as an independent step, independent policy, independent decision. One cannot say that such a decision has been taken in respect of one benefit arising out of that particular clause, then the other benefits, what they are seeking for, my lord, the comparing to the, my lord, the other sets of employees of the government concerned, then that should be followed also. That are my humble submission, that, my lord, they cannot be, because it's a policy matter. To what extent this benefit is to be extended, it is a policy matter. And my humble submission, so far these policy matters are concerned, my lord, the earlier notification, earlier, my lord, something, my lord, which has been granted in, my lord, arising out of that 38, because 38 is the main. 38 is the main. Now, certain benefits are further given and benefits in this sense that it is their money, they are allowed to take. It is their money. I cannot say that it is my money. It is their money. They're allowed to take lump sum at a time. Instead of 1/3, now 40%.
Lump sum was calculated for a period of 15 years.
Now, no, that is not. It does not appear that the calculation is based on that basis. It's a separate calculation. And my lord, this calculation is totally, my lord, in a different way. I am told that, my lord, I am told that it is, my lord, with respect to my lord, that is, my lord, the insurance policy, the certain calculation.
Please come to the affidavit filed on behalf of. Please come to the affidavit filed on behalf of KMDA. They have disclosed it.
Yes.
Ultimately, in terms of the order passed by this court, they have disclosed it. There are two affidavits. So I will take you to the last affidavit affirmed on behalf of the KMDA, which was affirmed on 16th April 2025.
Oh, regarding that clarification. এটা কোনো annexure নেই। Yes. Affirmed on. The affirmed on 11 September 2023. It's a report in the form of affidavit.
Yes.
September 2023. Yes.
Now, please come to page 3 of that affidavit.
Mine. I am on that. Yes.
Yes. For example, last paragraph. Please read it, Mr. Sen.
Paragraph number.
For example, there is a heading. For example.
That paragraph is paragraph number 9.
No. This is an affidavit affirmed on 16th April 2025.
16th April.
April. 16th April. There are two affidavits.
It are 2023.
Last affidavit affirmed on 16th April 2025.
Yes.
By the Chief Executive Officer of KMDA.
Yes. For example, a
Yes.
retired,
You will get it. The picture will be clear to you.
he retired on superannuation at the age of 60 years and applied for a commutation of pension at the rate of 40% of his pension on the next day after his retirement. Say his last basic pay was 20,000 per month. Commuted value of pension would be as follows.
Yes. Please turn the next page. Then superannuation pension was 1,000, 50% of 2,000, 1,000 only per month. Then monthly commutation up to the extent of 40% they were permitted.
10,000,
Like state
4,000.
government is then 4,000. Then yearly commuted amount of pension is 48,000.
Yes.
Yearly commuted amount of pension, that is 48,000, that is 1,000 plus 40% is 4,000. Then 4,000 into 12, it comes 4,000 multiplied by 12, it comes to 48,000. Then commutation factor, I will take you to that. That for 48,000 into 8 point commutation factor 8.194. Age of on his next birthday 61 years. Then commuted value of pension means for 4,000 into 12 into 8.194. Please turns to this annexure 2 of the regulations. It legible copy is at page 9 of the first affidavit used on behalf of KMDA.
KMDA.
26th March 2025, this affidavit was affirmed. Yes. Page 9.
Eight point.
Are you on page 9
Yes,
of the affidavit? Yes. Then this is annexed to commutation value for a pension of ₹1 per annum against ₹1 per annum. Then age is one of the factors in determining the commutation. Then the second column, first is age on the next birthday. Then commutation value expressed as number of years purchase. Straightway come to first, second, third, fourth column. Under the heading commutation value expressed as number of years purchase. Now, third column you will find that 61 at the bottom.
Yes.
Last but one, 61.
My
That is age on the next birthday. The meaning thereby, on attaining age of superannuation, if person opts for commutation, opts to commute. In that event, this methodology will apply that on 61 against age of 61. What was the commutation factor? That is against 61. You will find in the fourth column 9.81.
True.
That is the commutation factor, and this is an expert exercise.
Yes.
Based on value expressed as a number of years purchase. It is generally in consideration of 15 years, and that 15
number of years.
That 15 years gets fortified if you come to this relevant part of the writ petition, where there is an admission on the part of the KMDA that it was for a period of 15 years.
9.81 represents the time period by which the commuted value is refunded. 9.81, that annuity value.
Yes.
That is the time period by which the exact amount of commuted value is refunded to the employer.
No.
Yes.
That is not.
No, I have.
That is not. That is not. It does not appear. It is their interpretation.
Complicated, but this calculation is bit complicated, but it's an expert
yes
exercise.
The demonstration given by the KMDA also.
By 9.81, it is refunded to the.
Now, 12 years is the time by which interest is refunded, and 15 years is the prospective loss suffered by the employer by reason of those persons who are not living up to 75 years.
Where you are getting this?
That's the actuarial calculation. That's the statistical calculation.
It is not on record.
No.
Very intricate one.
Nothing. This is not
integrated one.
This is not on record.
We are working on this aspect commutation for a long period, but we need not enter deep into this issue in order to find out an answer to the question raised by the petitioners. Now, we come to page 130 of the writ petition.
Yes.
So 9.81 is the period during which this amount is to be refunded. Then up to from 9.81 to 12 years, it is interest is paid. Then from 12 years to 15 years,
the absorption of prospective loss for those colleagues who might not be surviving up to 75 years. Suppose one dies at the age of 65.
65 prior to 15 years. Yes, Mr. Sen, please come to page 138.
Yes, I am on that.
This is a letter addressed to the Joint Secretary to the Government of West Bengal UD Department. Extension of benefits of restoration of commutation portion to the pensioners of KMW and SA as at par to the state government norms after 15 years from the date of retirement. Now, first, second, skip over first, second, come straightway to third paragraph. Please read it.
It appears that the retired employees of KMW and SA who have passed over 15 years after retirement but did not get the benefit of restoration alike to the state government employees, although the annuity value has been fixed on the basis of 15 years span.
Yes, this aspect is very important. There is an admission on behalf of KMDA that annuity value has been fixed on the basis of 15 years span. So therefore, though a separate story was tried to be projected, by filing an affidavit in opposition that it is for an entire period, entire lifetime, but that is not the issue. Calculation was made considering 15
Calculation,
years.
my lord, no doubt about that. The calculation was made on the basis of a certain period. 15 years for this issue is very good, my lord, 15 years. Now the question is again, my lord, hovering that with regard to that restoration of full pension or whatever you have relinquished that for the eternity, or that you have because you have relinquished, you have waived your right, not only to that extent, you have waived your right permanently that for a certain period, this is your annuity, you get back, and no further claim with regard to the restoration. Because there is
it a feasible arrangement?
Because there is no such provision. Because there
Pension,
is
we
no,
are considering, we are working on a pension regulations. I am asking you,
my lord,
is it a feasible situation that a employee after retirement was allowed to commute to the extent of 1/3 or 40%, whatever may be the position, and after this period of 15 years, he will not get the benefit of restoration of commuted portion of pension. And lifelong, if an employee dies at the age of a retired employee dies at the age of 90 years, then from 75th year to 90 years, he will get the reduced pension.
my lord, the question is, my lord, that
Effect
I have
of your interpretation is this, and that too on a pension regulations, which requires liberal interpretation.
my lord, the only thing is that my submission is this, that after all this policy, my lord, I have not seen that particular pension regulation has been challenged. So kindly consider. My lord, may I just come to the prayers? May I come to the prayer once? My lord, the prayer is at page number 63.
Yes.
Page number 63. The prayer is that, well, Lord, she kindly come to prayer A at page 64. Not to give any effect or further effect to the order passed by memorandum number such and such dated October 8, 2009. That was the initial order of rejection by the finance, and then writ petition filed, and then, my lord, final again the order dated January 3, 2014. These two are the orders passed by the authority
8
concerned.
October 2009 is at page 122.
Yes. Now, my lord, and then the subsequent order
then
passed.
the decision of the finance department.
Yes. Now, my lord, these two orders passed after, my lord, so far the January 3, 2014 order, that after that, my lord, that the writ petition filed and then the order passed to
But
my humble submission.
I
Lordship.
will hear you. I will give you adequate time. Is it, in the writ petition, a case is made out, Mr. Sen, that 52(2), in view of presence of 52(2), there is no requirement to throw challenge to the regulations.
My lord, may I come again? Then again,
it comes in favor of the.
Then, my lord, again, then, my lord, what was my first submission before your lordship today? That 52(2) cannot bail him out or bail them out because of the fact 52(2) is not at all applicable, because the tenets of 52(2) is that when there is no such subject matter, here there is a subject matter. Because the question is not that with regard to any dispute or with regard to any, my lord, confusion or with regard to any interpretation. The question is that 52 within bracket 2 says that if there is no matter, that means subject. My humble submission, the subject is here. It is independent. We can read it independently. We can implement it independently without taking recourse to any other provision or any other law. So,
but whether the reasonable implementation is possible? So far, 38 is concerned.
Already implemented. So far the petitioners are concerned, my lord, may I tell?
Effect is preposterous.
Effect, yes. Now,
Effect of 38 is preposterous.
my lord,
An employee who is permitted to commute for a period of 15 years, after expiry of 15 years, he will not get the full pension.
but when they exercise,
He has to give this amount without any further benefit to the state government.
I'm grateful to your lordship, my lord. But the thing is this. My lord, keeping the same, my lord, regulation as it is, they have, my lord, they have opted and they have benefited the whatever the, my lord, and that has been acted upon by the parties. Lordship, kindly consider whatever the, my lord, the regulation speaks about, the parties before your lordship, they have acted upon. Now, my humble submission is this.
Implementation of regulation 38 does not take the employees to a situation where which is reasonable.
Madam, may I tell?
Which is reasonable.
Madam, may I tell? For the sake of argument, lordship, may I tell? Very good. It is not
Because you have to consider at the same time the effect of implementation.
My lord, it may not be reasonable in that sense. But the thing is this, unless and until that particular regulation is challenged before your
Both of
lordship,
us give money for a period of 15 years on a calculation of 15 years. And with an understanding that
I know that it's a very difficult situation, Mala, to argue, but the question is this, Mala, law point. So far the point of law is concerned, Mala, I am on that. I am on that point of law only. I know that the situation is very difficult for me, but so far point of law is concerned, my humble submission is this, that they have challenged this, that I am unable to give you because there is no in regulation. What the finance department said.
Policy decision.
It's a policy decision. So we have nothing to say. It is rejected. Whatever the recommendation or first of all, the recommendation from KMDA, and then my lord,
government policy can be so harsh.
My lord,
it's a welfare state.
That is, my lord,
without anticipating the effect of these rules.
My lord,
38.
I can, my
and
lord.
There are aberrations, Mr.
I
Singh,
can, my lord, may I
that
tell?
it was primarily up to the extent of 1/3. It was extended up to 40%. On what basis it was done?
My lord, I can tell only that so far that, my lord, the revision of pension and including the commuted value of pension, that notification or GO, whatever their memo, now I can say that is independently, nowhere it is stated that following any government notification or government, my lord, the rules, it is not there. It is there that since they have increased, we are also. But no mentioning that any government rules they are following. And it is not mentioned therein. That means, again, madam, may I tell, that nowhere it is the case of adoption. Adoption, no. Nowhere. So, when there is no such case of adoption,
Adoption to the what?
Adoption to any state government rules. What 52(2) says that mutatis mutandis shall apply. That means that adoption. But adoption, my lord, kindly consider one thing, all the time, not in general, adoption must be in a specific manner. If any other statutes are to be taken, adopted, then that should be specifically a particular provision, particular section. Here, there is no such specifically mentioned therein. Only in general says that any matter, and then in general shall apply mutatis mutandis. Case to case, maybe situation basis, and mutatis mutandis, my lord knows that to some extent, my lord, there may be some changes as it may require. But the thing is this, whatever that revision is concerned, from 1/3 to 40%, I have gone through, lordship, there is an independent. Then again, it's a policy. Lordship, kindly consider. Maybe on the behalf of the KMDA, but that amendment has not been carried out yet, and so far that 52(2), this has not been followed.
because there are no rules. It is not mentioned therein that yes, following that government order, following that government rules, we are doing this. So independently they have done this. Lordship, kindly consider. Now the
No, but without adoption, pending adoption, this was done with regard to extend.
Pending adoption.
1/3.
As if the language says so.
Extent of
Language speaks that.
commutation. That for from 30% to or 1/3 to 40%.
My lord.
Pending adoption.
My lord.
So without adoption, if this is done and without amending regulation 38, then why the similar procedure cannot be followed in case of permitting the petitioners to
Well, my humble
get the
submission.
benefit of
Well,
restoration of
yes,
commuted
what
portion of
fell from your lordship I have followed. My humble submission is this. Then the entire question comes, my lord.
Therefore, if the situation I will hear you. Situation emanates that more you can deduct, but you will not get back anything after 15 years, that deducted portion.
No, my lord, may I tell one thing?
Think about the situation, 1/3 to 40%.
That is
It's
true.
like Alibaba and Chalis Chor. You can enter into the cave, but you cannot get out.
Now, my lord, after all, my lord, the
From 1/3 to 40%, this was permitted by without amending regulation 38 and pending adoption.
Pending
so
adoption.
more can be deducted.
No, that means.
But after 15 years, you won't get it back.
That means it is your money. You may get it now. 1/3, now up to 40%.
Never get it back.
But the question is
But the concept, Mr. Sen, it also troubling me also. Very concept of commutation is that it's an deduction of lump sum amount or a deduction, a part of pension is to be deducted in order to get the benefit of lump sum amount for a particular period. But does it mean that it will take away the right of the pensioner to get the entire pension after the expiry of 15 years?
No, my lord.
Think about this, Mr. Sen.
No, my lord, the thing is this, lordship.
Is there any, you have given given an answer so far, other organizations are concerned, where there is no provision for getting the benefit of restoration of commuted part of pension or commutation of pension. But have you come across any situation where apart from 15 years, any other period is fixed for commutation?
No. No.
That is 15 years.
No.
Everywhere.
Yes.
In case of teachers, in case of government employees,
Yes.
everywhere you find it is for a period of.
Even I think in case of central government also.
It is 15 years.
15 years.
So the concept is this. Before doing, we both of us were practicing in service jurisprudence. Before doing this, I have not come across a situation where a retired employee is permitted to commute and after 15 years he will not get back the
Because, my lord,
of pension.
Because, my lord, this situation, my lord, we have not, my lord, come across earlier. So, my lord, but the thing is this, lord, you kindly consider one thing. One is this, my lord, so far that their hardship or this aspect. And the other thing is this, my lord, so far the point of law is concerned, kindly consider one thing, that particular regulation has not been challenged before your lordship. Kindly consider one thing, that it has not been challenged. The challenge that has been thrown to, that is the order passed by the, my lord, the executive.
So regulation 38 is not under challenge.
Regulation 38 is not under challenge. That it is a discriminatory or nothing. Ultra-virus, nothing. Or in comparison with other discriminatory, nothing. What they have challenged, the challenge has been thrown to the order passed by the executive. Now the executive passed the order on the basis of the regulation. Let's kindly consider. Executive also passed this order.
Please, the order of the principal secretary.
Yes, my lord, kindly come to one.
Yes. First
One-
order is at page 122.
No, that is not
Nothing.
relevant. Relevant is
They-
157.
Yes.
157. One 58. 158.
Yes, page 150. Place it. If you want.
Lordship, kindly come to third paragraph. First paragraph is the introduction that under what circumstances
here.
they are not required.
Place it.
Third paragraph. First, second, third paragraph. The matter.
Yes.
The matter has duly been examined and the contents of the petitioners being retired employees of the KMDA as recorded in the writ petition have been perused. The KMDA, in exercise of the power conferred by Section 139 of the West Bengal Town and Country Planning and Development Act 79, has framed a regulation which is called the Kolkata Metropolitan Development Authority Employees Death Cum Retirement Benefit Regulation 1998. In terms of clause 38 of the said regulation, an employee of the KMDA who is eligible for pension under the aforesaid regulations shall be entitled to commute for lump sum payment of portion not exceeding 1/3 of the pension subject to certain eligibility conditions. The said regulation also enumerates about the sanctioning authority and other requirements for grant of such commutation of pension. But no provision regarding restoration of commuted portion of pension is contained in these regulations for the KMDA employees. The state government has a separate group for government employees, namely the West Bengal Services Commutation of Pension Rules 83, wherein the provision has been laid down for restoration of the commuted portion of pension after 15 years from the date of superannuation. So it is amply clear that unless an amendment is brought about in relevant regulations of the KMDA by providing provisions for restoration of commuted portion of pension after adjudging the overall financial feasibility, the petitioners cannot be granted such benefit in their favor. It further transpired that the Honorable Court has directed that a policy decision has to be implemented for the writ petitioners in the instant case. This government has not yet taken any policy decision in regard to grant of such benefit of restoration of commuted portion of pension for the pensioners of statutory bodies undertaking local authorities, etc. Admittedly, the School Education Department, as referred to in the writ petition, has revised the pensionary benefits of the recognized non-government educational institution employees sponsored, aided by their memo number such and such, dated 29th of June 99, consequent upon revision of pay order, pay under their number such and such, revision of pay and allowances as a matter of policy decision. But benefit of such policy decision neither taken nor extended to any statutory body or corporation. The circular issued by the KMC regarding restoration of commuted portion of pension of its pensioners appears have not been issued under the cover of any policy decision as referred to in the judgment. It is made clear that proposal for amendment of a regulation can only be considered when additional expenditure required for extending such financial benefits, restoration of commuted portion of pension to the KMDA employees at par with that of the state government employees could be borne by the state statutory authority from their own resources and not depending upon the state exchequer. It has been brought to our notice that KMDA presently has a very meager income from its own resources. In a recent communique, the authority has stated that the salary and other allied financial liabilities are met out of the amount sanctioned to KMDA by the state government within the accommodation of state budget. So it is amply clear that KMDA is not a position to bear the additional expenditure for according such benefit to a large number of its employees. Hence, this is the order. Hence, the conclusion is, hence the finance department is unable to accept the proposal for restoration of commuted portion of pension to the KMDA employees at par with the state government employees.
Now come to page 159, second paragraph. It further transpires that the Honorable Court has directed that the policy decision has to be implemented for the writ petitioners in the instant case. The government has not taken any policy decision in regard to grant of such benefit of restoration of commuted portion of pension for the pensioners of statutory bodies undertaking local authorities. Is it correct?
What it appears here,
Not correct. Because in municipalities and other local authorities and as well as in Kolkata Municipal Corporation employees, they are getting the benefit of restoration of commutation portion of pension.
No, it is stated that the government has not yet
Please,
taken any
please
policy
read it
decision.
again.
Yes, government not even. Maybe they have.
The transfer that Honorable Court has
The
directed,
KMC
policy decision has to be taken implemented. This government has not yet taken any policy decision in regard to grant of such benefit.
I think, the government.
Grant of such benefit of restoration of commutation portion of pension for the pensioners of statutory bodies. You have given it only 3 or 4 organizations where this benefit is not restored.
No.
Is it a case of Kolkata Municipal Corporation that the employees of KMDA, KMC are not getting the benefit of restoration of provisional committed portion of pension?
Page 143 and 144, such example.
143 and 144?
Death come retirement benefit regulation 2000. Terms to 144 coming to pension.
See the decision making process and what was the consideration. And there was no discussion with regard to regulation 52(2), whether it comes into play or not.
No. What I am on this, that the order.
This is the wrong consideration. I am telling Mr. Sen. It further transpires that the Honorable Court has directed that a policy decision has to be implemented for the writ petitioners in the instant case. The government has not yet taken any policy decision in regard to grant of such benefit of restoration of commuted portion of pension for the pensioners of statutory bodies undertaking local authorities. This is not the correct position. Employees of Kolkata Municipal Corporation are not getting the benefit of restoration of commuted portion of pension. Answer is no, they are getting. You know better than anybody.
I think, my lord.
And the employees of municipalities.
Employees of municipality, my lord, I think
Same thing.
Kolkata Municipal Corporation is getting.
Page 160. See the position. Far back in 2010, restoration of commuted portion of pension comes to pay. Please come to page 160.
I am on.
And that's why I have requested you to read this decision. Let us read it together. Where from this principal secretary has imported it?
This is, my lord, I think, might have, I do not know, my lord, but might have that it is from Kolkata Municipal Corporation and whether this is, my lord, the policy of the government or policy of the Kolkata Municipal Corporation, but it appears that finance department sanction, yes.
See the nature of consideration by the principal secretary.
No, also it appears from that the finance department approved.
And on the next page, they have petitioners have annexed this order relating to Kolkata Municipal Corporation.
No, that is school education department. ওটা আমরা admit করেছি. School education department that has already been admitted. Yes.
School, it is already there, long way.
Long back, nothing new. But super KMC in 2010.
In death come retirement benefit scheme 1981.
1981. 1981.
So already provision is there.
There was.
15th March 1985 notice. From 1985 it is there.
My lord.
And it is applicable to the retirees who retired from the 1st of April 1981 onwards.
Question is then again hovering around is that whether, my lord, the state government should be compelled to amend or to issue a policy decision by way of this, my lord. Only thing, my lord, what I am thinking about this, that whether, my lord, the court can direct, my lord, to frame such a policy decision.
Just a minute.
সাড়ে ওখানে ফিক্সড ম্যাটার আছে ওই যে লয়ার কে পিটিয়েছে নাকি হোক আমার ড্রেস দরকার খারাপ হয়ে যাচ্ছে পারছি না রেগুলার আপনি 1:30 2টো কালকে 2টোর সময় শুয়েছি বড় অ্যাপিল দিয়েছে
Yes, Mr. Sen.
No, my lord, I know, my lord, that that is a beneficial legislation, and if the other entity or organizations, if they are, my lord, allowed by the finance department to adopt this,
Similar
to amend, then why not? Then only, my lord, my answer would be that there are 1 or 2 case law I can, my lord, cite before your lordship is there. That pension regulation, yes, it is a beneficial legislation, Supreme Court said, and also said at the same time that whatever is there in pension regulation, it should be read in this manner.
It should be interpreted liberally.
It should be interpreted liberally, but so far the
on the anvil of this this view expressed by the Supreme Court, is it proper so far this court is concerned to accept your submission that in terms of regulation 52.2, regulation 52.2 shall not apply in view of presence of regulation 38?
My lord, my only submission is
that would lead to hardship of the pensioners.
Maybe
How do you react to this?
My lord, that is true. But my lord, at the same time, the financial burden that would be on the, my lord, the state government, and on that aspect, the Supreme Court said in, my lord, pension matter, that the contours of the benefit arising out of any pension scheme shall not be extended to that extent, so that the financial burden would be on the state government further enhanced. There are judgment that contours. Supreme Court said yes.
Whether the court is trying to, or is it a case made out by the petitioners to extend the benefit of pension rather to restore the benefit of pension?
It's a very important question. I'm grateful to your lordship. It's a very interesting one, and very an important one of the thing is this. That whether
it is a case of extension of benefit or restoration of benefit.
Yes.
Yes.
May I pray one thing? My one matter, my lord.
No, you conclude it. No. I will not permit you further because I have accommodated state on for a long period of time.
My lord. No,
anything required to be agitated further, Mr.
My lord, only, my lord. So far, my lord stand so far that argument is concerned that it's a policy matter. Now, my lord, lordship And so far, the employees of the KMDA, they cannot be at par with the, my lord, the state government employees. Lordship, kindly, my lord, allow me 2 or 3, my lord, case law, my lord, may I?
2 or 3?
Case laws, Lordship. May I please?
Yes, yes.
It daw to, 2019-4.
On what proposition of law?
My lord, the proposition of law is that the any, my lord, the extension of the contours of the pension scheme by of giving any, my lord, the benefit further, if that
There
involves.
should not be any extension of benefit of pension.
Yes, I mean, what is there, that should be there, that is.
Yes, yes.
And on that score, Lordship, 2019, volume 4 SCC.
2019?
Volume 4 SCC.
Yes.
Page 479. And my lord.
Paragraph?
Paragraph 18 and paragraph 26. Paragraph 18 and paragraph 26.
Yes, then?
No, but may I read out paragraph 18? Lordship?
Not required. I will go.
Only, my lord, for my satisfaction.
No, I will go through it.
Very good.
Yes.
That
you indicate the paragraphs. Yes.
Yes. And then, Lordship, 479 days. And my lord, on that point, that employees of state-controlled corporation or, my lord, any other independent bodies for whom that, my lord, there is separate TCRB regulation or pension regulation, but they cannot be treated on a par with the, my lord, the state government employees. And that is, my lord, 2016, volume 10 SCC.
2016?
Volume 10 SCC. Page 77, paragraph 90. Only one paragraph, my lord, suffice to.
Paragraph 90?
Paragraph 90.
90.
My
State government employees should not be at par with the.
The employees of undertaking or other body corporate should not be treated at par with the, my lord, the state government employees with regarding to the service benefit. And my lord, the
should not be treated at par with government employees.
My lord, with regard to their service related benefits. The Supreme Court says that it is not possible for us to accept that the employees of.
Yes, where is the judgment? Copy of the judgment?
It is not possible for us to accept the employees of corporate bodies can demand as of right to be similarly treated as government.
You don't have a copy?
Yes.
Yes, give me a copy. Yes, paragraph 90.
90.
Just a minute.
Paragraph, paragraph 88, then 90 and 95. Para 88, then 90 and then 95.
Yes.
আচ্ছা 2022 ছিল 2022 তুই আছে না আচ্ছা এখানে
Past judgment 2019 for SCC is on the proposition that pension benefits cannot be expanded.
Yes.
Then
and another is that if it is extended, then the involvement of financial burden would be there. So that should not be.
So second is 2016-10 SCC that the benefit should not be at par with the state government or government employees
with regard to the service benefits.
Service benefits. And the third one is
And third one is, my lord, with regard to, my lord, that the waiver acquiescence. Because
citation
is lordship to 2022.
Yes.
Volume 2 SCC, page 25, paragraph 25.
Waiver and acquiesce.
My lord, that if, my lord, a known right is waived, that it is my known right that I have to get back. But
So
I
your
waive.
contention is in terms of 38, regulation 38, when they opted for commutation. When they opted for commutation, they have waived their right to get back
their right to
get
back.
the benefit of restoration of commuted portion of pension after 50.
Because knowing fully that there is no such provision. Knowing fully that
Yes,
there is no
very
such provision. And that is, my lord, this judgment.
Paragraph 25.
Paragraph 25.
Anything more?
My lord, these are.
Concluded. Where,
And my lord, one thing that, my lord, that they have not challenged the, my lord,
yes, that I have noted, that the regulation is not under
regulation.
My lord, one line.
What?
There, if my lords, we have sought for a visa of mandamus, my lord.
When Mr. Mujumdar will get a chance to give reply. It's,
My lord, one line. May I?
Mr. Amol Kumar Sen, learned additional government tutor. Mr. Amol Kumar Sen, learned additional advocate general, appears on behalf of the state respondents and has concluded his submission.
Stop. Well, may I leave, lordship? One fixed matter at 4:30. Code number 35. Which is lawyer के लिए
এই এটা কবে আছে দেখো তো, ওই টিচার্স যেটা প্যারা টিচার্সদের ইয়েটা ফিক্স মার্কস। Fourth September at 3 p.m.
4th September.
Means the matter under the heading, under the same heading, on 4th September as 3 p.m. fixed matter.
My lord, here, so far the third point taken by my honored friend, my lord. In written note, my lord, I have stated that point. I have also taken.
Yes, you have to.
In the written notes, I have filed. I have relied on two judgments on 52 subclause subsection 2, and regarding that option, that this regulation was notified in 1990, whereas the implementation they are seeking, my lord, of 1987. So 87 notification existed when this 88 regulation was framed. So it is consciously not incorporated in 1988 regulation, because 87 they are seeking implementation of 87 notification, which was framed under the West Bengal Services Commutation of Rules 1983. They are seeking.
By 87 there was an enhancement from 1/3 to 40.
No, 15 years restoration.
That is 83 regulations.
83 regulation, the 87 memo was issued pending formal amendment to the rules. They are seeking in the prayers, they are seeking that this memo should be made applicable to these petitioners also. So here, my lord, my submission is, my lord, on that, my lord, I have taken point in my written notes that 88 regulation, so far the KMDA, DCRB regulation was notified in 1990. It's 88 regulation. So 87 existed then. So restoration, provision for restoration was there in 87. But in DCRB 88, that was not incorporated. Only 38 was incorporated. Commutation was incorporated, not the restoration. So knowing this situation, they have opted for coming under the
এই
88.
দাও তো দেখি এই এটা এটার মধ্যে এইটা নোটটা আমার ঢুকিয়ে রাখুন।
That I have indicated in my written notes.
Very good. So your contention is this, so far the commutation is concerned, there was a provision prior to 88 regulations, so far state government employees are concerned, but consciously this regulation was framed.
Restoration
But
was-
subsequently extension of benefit from it, extension of commutation of pension from 1/3 to 40%.
That was
This was subsequently made, that's why this was followed.
Yes. That was
When
with
this was made.
That was with the my lord, government permitted to enhance that.
Yes,
but not the amending the regulations.